in the construction industry should be aware of. It is also to encourage everyone to read the law cover to cover, because we are all technical people. Doesn't matter whether you are an engineer or like myself, I'm an architect. It is an open secret that technical people like us, we don't we have some kind of like difficulty to read the law cover to cover, because it is text. There's no pictures, there's no diagram, there's no numbers. It is fully text, like law students. But anyhow, our industry is governed by the law of Malaysia. 100% whatever that you do within this construction industry, it has to be based on the law of Malaysia. So whether we like it or not, we have to read the law cover to cover, so that we will not miss any part of the relevant law that we are referring to. So we group all the sessions, 19 sessions, to 5 themes. The first theme is on professionalism. So we have Act 138 together with its subsidiary legislations, which are the Registration of Engineers Regulation 1990. We also have the BM Scale of Fee 1998. We also covered on 2003, the one for housing development. And then the second theme is on development process. So we have the National Land Code, Town and Country Planning Act, Environmental Quality Act 1974, Act 133, and then its subsidiary legislation, the UBBL 1984. And then also UBBL 1984, we split into 3 parts. One is the constructional requirements, and part 1 until part 6. And then part 7 onwards on fire requirement, we split again into 2 separate sessions on passive, and then we have active fire requirement session. We also have the Housing Development Act and Strata Titles Act 1985 together with the Strata Management Act 2013. So that concludes the topics on development process. It is always land, planning and building. Do not immediately jump to read Act 133 without reading the National Land Code and Town and Country Planning Act 1976. Also the Environmental Quality Act. Because you cannot submit for any building that you would like to erect, you cannot simply do the submission without having the approvals done on land matters followed by the planning matters. Land must be cleared first, all the approvals required, and then you move on to the planning. Lastly, only that you enter on building. There are many of us simply do this type of mistake. They immediately jump into building. For example, there is a client that would like to appoint you to design a bridge, for example. Immediately you feel very excited. Oh, I have this client who would like to appoint me to design a bridge. And then you immediately start to design, buatlah bentuk macam spaceship ke. And then you immediately jump into the design, and then you submit to your local authority, and then immediately you will get rejected because you have not resolved your land matters. No approval have been obtained yet. You didn't even check what is the land use category, what are the restrictions on that land, okay, and then are there any caveats on the land you didn't check. Same goes to planning. You didn't check the zoning of the land, and then what are the garis-garis panduan existing under JPBD that you need to comply with. No approval means you cannot proceed to building. Okay, land, planning, building. It is always that way. Then the third theme is on contract, because we already start to move on the construction site. So the mother of all contracts, standard form of contract, whatever contract that you're doing in this country is governed by the Contracts Act 1950. That's why we put Contracts Act 1950 at the first place. Then we also have the Occupational Safety and Health Act 1994 and OSHIM yesterday. We have already covered this. So for today onwards, we are going to into the standard form of building contract. So we have PAM contract 2018 and then JKR contract 203A. Okay, and the last part to conclude the theme of the contract is the Construction Industry Payment and Adjudication Act 2012. We will go into this on the session number 17. This one is about payment. The last theme number 5, will be on services. So we have water, electricity, and gas. We covered these 3 lah. Of course, aside from all these 19, there are more law of Malaysia that everyone should be reading of. But we cannot cater for all the topics, or else we will have apa tu, IR 2024 will be a whole year webinar. Tak boleh lah. Tak boleh lah. We cannot have a whole year webinar. Tak berhenti dia punya kelas dia sebab terlalu banyak topik kita nak cover. We only cover 19 sessions sajalah. Kalau tak, saya tak boleh pergi holiday lah. I want to have my leave as well. Anyway, It is a not-for-profit webinar series initiated by a team of practicing architects and PEPC, organized by Amos IT Consultants. So we are a registered training consultancy under Suruhanjaya Syarikat Malaysia. We are registered people lah. We are not scammers. Because every year I keep on receiving this message. Are you a scammer? I said, no, we are not scammer. We have been running this webinar for 4 years already, and it is a BEM pre-approved CPD program. So we cannot be a scammer lah. Kalau BEM pun dah approve kita punya program. So this one is the 4th year. We started to do it in 2021 and then 22 until 24 now. But prior to IR webinar series, we actually initiated with the webinar for architects first. We started in 2018 actually, and that time we used to do the webinar for free. For all architects, graduate architects to join and learn the law together. But of course, when we do it for free, people took things for granted. There was one session, there were a group of 10 graduate architects approached me asking me to do some classes for them on this particular related law. So I said, okay, fine, we can do it on this particular day and time. And on that particular day and time, out of these 10 people, 0 attended. I was so disappointed with this kind of thing. So that's why since then, we started to put a minimal charge. I started to put a minimal charge of 20 ringgit per person per session as a commitment fee only. We are a not-for-profit. We are not seeking for profit. Because if we want to search for profit, the cost of the webinar will not be 20 ringgit per person. It will be, I don't know, 150 ringgit per person ke, especially kelas yang ada a very experienced speaker, kita letak harga lebih mahal lah. We are not seeking for that. So the objective of this webinar is as a platform to encourage an interprofessional dialogue and knowledge sharing among the construction industry community. So we work together. Doesn't matter from which profession you are, we work together because everyone is looking down on all the consultant in the construction industry now. There's no point of, for example, I'm an architect myself. There's no point for me to say, engineer teruk. Lepas tu engineer pula kata, architect tak tahu apa-apa. What is this? What's the point of this kind of accusation? There's no point. There's no point. We are all in a same team together, and the whole public out there are looking down on all of us. Why not we work together? Let's learn the law of Malaysia together. We protect each other, and then we can elevate our profession in the eyes of the public together. Okay, for your information, I come from a family of engineers. My father is a civil engineer, my siblings are mechanical engineer, aeronautical engineer, another one is a structural engineer. I'm the odd one out. I'm the only architect in the family. Anyway, another reason is for us to provide an affordable peer learning in relevant law related to the construction industry. So for PEPC or for PE, if you would like to collect your CPD points, not just for PE lah, those also registered with MBOT, Malaysian Board of Technologies, you can obtain your CPD points at an affordable rate. This is our intention. Because as you know, CPD points, CPD events out there, they are very expensive. I think I shared with the class before, when I first graduated, I would like to collect CPD points. At that time, I was a graduate architect. There was one seminar that I was really interested in. It was about development on hill slope area. It was a one-day event from morning to afternoon. Until afternoon, and the fee was 1,200 ringgit. Imagine me just got my first salary. I cannot afford to pay 1,200 ringgit for that seminar, even though I really would like to attend. So we try to understand everyone's situation. CPD is a continuous learning process for everyone. We try to make it as affordable as possible for everyone. So I also received question, do I have the intention, say, if we are about to do IR 2025 in the future? At the moment, I do not have the plan to increase the price because we are not seeking for profit. Except if there is a rise in electricity punya rate ke, ataupun Microsoft Team increase the price triple ke, then I have no excuse but to raise the price. But at the moment, we are still able to sustain the webinar at 20 ringgit per person. We're still able to run this webinar series, even though the budget is very tight. So I'm being very transparent. Where does this 20 ringgit will go into? Number one, it will go to Microsoft Teams because I purchased the full version of Teams. And then another option, we also have Zoom. We also have Zoom as an option in case any technical problem happen with Microsoft Teams, because we never know. Sometimes the server down ke, at Microsoft ke, we never know. So we have a secondary option. We also have Zoom to backup. Is to pay for these 2 licenses, a full version, and then pay for the speaker. There must be a token for the speaker for their time, because we purchase their time. We invite them to come in, and then to the admin at the back for those people who prepare the receipt, the flyers, and then those people who are working on Saturday and Sunday, because their rate is not the same. In comparison, if you work on a weekday, the rate is a bit higher, so we have to pay that. We have to pay for our accountant, and then we have to pay for tax. So you can calculate yourself. We are all consultants here. You know that, say, if today's class we have 100 people, times by 20, we get 2,000 ringgit per session. And this 2,000 ringgit is memang ngam-ngam je lah. Ngam-ngam je lah untuk run this webinar for one day. For one day lah. Okay, faham ah? So for information as well, R2024, it is a BEM pre-approved CPD program. So we have obtained, each session is granted 3 CPD hours by BEM. So if you join 19 sessions, you will get 57 CPD hours. So you can put aside your worries where to find my CPD point away. Dah tak perlu fikir lagi, because you need 50 kan. For MBOT, you need 30. For MBOT, we did apply for CPD. For information, we are approved training provider, dipanggil ATP, MBOT approved training provider. Yes, we are an approved training provider. And we have applied for CPD for IR 2024. Until today, they are still processing. Lambat betul lah. Saya memang panas betul dengan MBOT ni. Kata teknologi patut cepat lah kan, tapi dia masih proses lah. I will chase MBOT again next week, because I also would like to claim my CPD for MBOT. I'm also a registered professional technologist, so you are not alone. I will choose for MBOT again next week. So we would like to thank Board of Engineers Malaysia, BEM, Suruhanjaya Tenaga, Indah Water Consortium, Jabatan Pengairan dan Saliran, JKR, DOSH, Universiti Teknologi Mara Infrastructure, Universiti Kuala Lumpur, for making this webinar easy for us to conduct. Their indirect and direct support for us to have this happen for 4 years already. Okay, reminder to everyone, in compliance to the Copyright Act 1987 or Act 332, no form of digital, audio, photographic recording is allowed either for distribution, display, or personal keep. Participants' microphone is muted by default. Participant may ask question or respond to the webinar via the chat box. We have a chat box here. You can type your question in the chat box, so we'll have a look at it from time to time. Sign out link for CPD claim will be shared in the chat box at the end of the webinar. So by 5 p.m. we will share the sign out link, and you have to fill up the sign out form for you to claim the CPD, and also for our record. We will also project the QR code on the screen. Okay, so either way, you can scan the QR code, or you can just click the link on the chat box lah. Here, so that you will have a record. Once you click the submit button, you will have a record of your attendance. You'll get a copy of that Google form lah. So in case we submit the CPD to BEM and MBOT, say your name is not there, at least you have an evidence that, hey, this is a proof that I attended the session. You have the evidence of that lah. Okay. All right. Just a bit about organizer, because there are quite a lot of people who just would like to join the contract session today. So who are we actually? We are a sole proprietorship registered training consultancy under Suruhanjaya Syarikat Malaysia to provide affordable peer learning and knowledge sharing to the construction industry community. So these are our business detail. We are not scammer. Aku scammer. Do I look like a scammer? Hey. So we conduct seminars, webinars, and workshops to the construction industry community, such as to architects, engineers, inspector of work, developers on statutory laws, on subsidiary legislation, and whatever issues within the industry. So these are the range of topic that we're able to cover. Beyond that, if you ask me, Architect Amy, can you conduct a session for me about a poison act, whatever year? I have no idea. We cannot conduct that. We are within the construction industry only. So outside the construction industry, please look for someone else. I know I cannot lie that, oh, okay, I can provide the training for that. Sebenarnya kita tak tahu apa-apa pasal benda tu. Why I only limit this webinar within the construction industry, or even seminar that we conducted physical, because it is something that I, as an architect myself, can monitor. So if any of the speaker tipu ke apa, I am alert. I can be aware of that. It is something within my control. Something beyond my control. Saya nak jadi broker ke? I'm not interested to do that. Okay. Um, And then these are the photos lah, gambar-gambar seminar physical yang kita pernah buat, like IR 2023 or sorry IR 2024. It is public class. This one is public lah, a class for public. We also do individual or private training for organizations. So for example, there are a group of candidates who are sitting for PEPC, for example, PEPC, PCE exam, you have 10 people you would like to organize a certain topic, yes, we can provide the training for that. Or you might want to have an in-house training for your office for a certain topic, then we can arrange for that. That is how we do. Like RR 2024, this one is a general public class lah. Okay. Ini gambar-gambar training yang kita pernah buat lah sebelum ni ah. Some of our speaker punya gambar pun ada dekat sini lah. This one is a physical seminar. Ada yang a small group, ada yang in a smaller office, a medium size office, whatever lah that you would like to learn the law that we can provide. Okay, we also have online webinars. We have conducted online webinars since COVID. Sejak zaman COVID 2020, kita move. We also provide an alternative for online. Okay, so hierarchy of law in Malaysia, saya cover ni sikit saja that everyone needs to understand how does the law of Malaysia works. Okay, hierarchy of federal law in Malaysia, the highest law in this country is the federal constitution. There is no other law that is higher than the federal constitution. So who made this federal constitution? The answer is the owners of the land. The owners of this country. Who are the owners of this country? For Semenanjung Malaysia, the owners of this country are the Majlis Raja-Raja Melayu. They are the ultimate owner of the land. It is stated under the Federal Constitution. Okay. And then what about for Sabah dengan Sarawak? For Sabah and Sarawak, the owners of the land are the representative of the natives of each of the two states. Okay, ada macam-macam kaum lah dulu kalau kita baca about perjuangan untuk kemerdekaan. For example, for the state of Sarawak yang menentang Raja Putih dan sebagainya. Each of these natives, setiap jenis kaum dekat Sarawak, for example, they have their own groups. Lepas tu, and then later they evolve to become political parties and whatsoever lah. But they have the representative of each of the natives of within their states. Yeah. So when you combine these two, it form this federal constitution. So prior to 1963, the formation of Malaysia, when Sabah dengan Sarawak decided to join together with Semenanjung to form a new country, sebelum tu nama dia Persekutuan Tanah Melayu. So this federal constitution back then was only about Persekutuan Tanah Melayu. And who made this federal constitution? Majlis Raja-Raja Melayu. Together with the assistance, masa tu Suruhanjaya Reed, Suruhanjaya Cobalt towards kemerdekaan dulu. Kita ada belajar benda ni masa sekolah. So their land, their law. So when Sabah and Sarawak decided to join, to merge and to become a new country in 1963. So this constitution went through amendments. Ada pindaan, benda-benda baru yang ditambah. Okay, the requirements from the representative of the native of Sabah and Sarawak, they said we would like to add this and that into this constitution because they are the owner of the land. Okay, so that's how this federal constitution was made. What about the rest of us? The rest of us are just nobody. The rest of us are just nobody. So whatever is stated in this constitution, it has to be complied with by everyone, whether you like it or not. There are also things that I quite don't understand under the constitution, but who am I to say? Their land, their law. Okay, so when it comes to federal law, the highest is the federal constitution. So below the federal constitution, we have something known as the acts. Acts consists of acts and codes. For example, Registration of Engineers Act 1967, Contracts Act 1950, and then we also have codes like National Land Code, Penal Codes, whatsoever. So below the acts and codes, it gave birth to smaller laws known as the subsidiary legislation. Example of subsidiary legislations are like rules, regulation, order, bylaws, and whatever other names. Okay, I give an example. Registration of Engineers Regulation 1990. It is a subsidiary legislation of the Registration of Engineers Act 1967. Dia anak dia. Okay. And then at the lowest level, the lowest of the lowest, ni golongan hamba abdi bawah ni. Ada guidelines, garis-garis panduan, manual, circular, standard dan whatever else lah. Yang ni level paling bawah sekali. So which one you should be reading first? You should be reading from top to bottom. You should read the main one first. Federal Constitution ni at least once in a lifetime you have to read. so that you will know what are the terms and conditions as a Malaysian. How does this country works? Why is it like this? Why is it like that? All the whys. Why this country macam ni macam tu? The answer is all inside the Federal Constitution. Jawapan ni memang dah ada dalam tu. Okay. So from top to bottom. Okay, so let us use the correct terminology. Every single item inside the Federal Constitution is known as article. Article 1, Article 2, Article 3. For acts and codes, every single item inside an act and code is known as section. Do not use any other term other than section. Ramai orang suka sebut clause lah, kan? Kaedah lah, peraturan lah, entah whatever name lah. Macam-macam nama. Jangan sebut macam-macam nama. Section. Section 1, Section 2, Section 3, Section 2000. Okay. For rule, regulation, order, and bylaw, the name is stated there. For example, like building bylaw, Uniform Building Bylaw 1984, for example, there are many bylaws inside. Every single item inside that document is known as bylaw. Bylaw 1, bylaw 2, bylaw 3. Lagi apa lagi? Strata Management Bylaws 2015. Every single item inside that is known as bylaw as well. Bylaw 1, bylaw 2, bylaw 3. Apa lagi contoh? Regulation. Registration of Engineers Regulation 1990. Every single item inside the regulation is known as regulation as well. Regulation 1, Regulation 2, Regulation 3, Regulation 9999. Do not use any other term. Saya pernah dengar ada engineer sebut yang under Registration of Engineers Regulation 1990, dia refer tu sebagai section kat dalam tu. Tak boleh, tak boleh. Section ni dia macam gelaran hanya untuk acts and codes. Dia macam title orang bangsawan tau, Datuk Seri, Tan Sri. Macam tu lah. You cannot use the word section untuk golongan orang biasa. Tak boleh. Okay. Alright. So, what about the conditions of contract when it comes to the standard form of contract? Whatever contract that you're doing with apa-apalah contract dalam Malaysia ni, your employment contract ke, your prenuptial contract, this one is related to our topic today. Your sales and purchase agreement, hire and purchase agreement, your employer-employee contract, the agreement between directors in a board of director of a company. Okay, every single item inside the conditions of the contract. Okay, on the conditions of the contract is known as clause. Clause 1, clause 2, clause 3. Unless stated otherwise. Entahlah kalau dipakai nama lain. Pakai nama clause. Alright, so where to find all this law of Malaysia? All this law of Malaysia is free to download from the Federal Constitution Act and subsidiary legislation. Just go to lom.agc.gov.my. Yang ni bukan website scammer. Yang ni memang AGC punya website. Official website. You just click whatever that you want. Type in the name or the keyword. And then, for example, you click on the act, you can download the latest one. We have act number 855. Okay, yang ni Preservation of Public Security Sarawak Act 1962. Tengok, yang ni baru keluar, gazetted last month. Baru. Subsidiary legislation, the latest one, baru ada, 3 hari lepas baru keluar. Peraturan-peraturan custom 2024, baru keluar. Ada lagi, banyak pula yang keluar yang 3 hari lepas ni. Peraturan keselamatan cyber keluar juga 3 hari lepas. Peraturan keselamatan cyber lagi, cyber. Macam-macam cyber dekat sini semua keluar 3 hari lepas. This is fresh from the oven, baru lagi keluar ni. So dia tulis date of commencement. Tengok yang nombor 2 tu, date of commencement beginning tomorrow. Nampak tak yang nombor 2 tu? Peraturan keselamatan cyber 2024 beginning tomorrow. Date of commencement pun dia ada tulis Okay, so daily update is available. Yang ni saya screenshot on the 10th of August. So you see every single day there will be a new update lah. So for you to always go to agc.gov.my website and see what is the latest one. If you have an old law, take it and throw it away. Kalau dah keluar yang baru, the old one has already become obsolete. You cannot use it anymore. You have to refer to the latest one. Okay, so about the speaker today, Architect Fakri Rahman. I've known Architect Fakri for very long. Very long. He's a friend of mine. And I always trusted Architect Fakri to come and share his knowledge when it comes to contract. He is a very reliable person when it comes to contract. So he is a principal of Fakri Rahman Architect. And for your all information as well, where we studied for the professional examination, we get to know each other back then. That was like a long time ago. And Architect Fakri has been sharing in our webinar series and even the physical seminar series since the last 6 years. So dah 6 tahun dia keep on sharing with us. Why I call Architect Fakri? Because like I said, I will not simply call any person who I do not trust and who do not read the law cover to cover. He is one of the people that I know of yang memang read the law cover to cover. So that's why saya berani panggil dia datang mengajar. Siapa yang tak baca law cover to cover, saya akan tanya dulu, did you read the law cover to cover? Oh, saya tak baca. Tak baca, saya takkan panggil dia jadi tukang mengajar. Okay, so without any further ado, I will pass the class to Architect Fakri Rahman. Okay, Fakri, are you already here?
Yeah. Hi,
Okay. Dah masuk. Okay.
Alright.
Sorry ya, terpanjang pula because I thought you're not in yet. Alright. Okay, I'll pass the class to you, Fakri. Thank you.
Okay. Very good morning. I share the slide first. Okay, can see the slide.
Okay, nampak.
Okay, nampak. Full. Okay. Assalamualaikum and a very good evening. Bid to all. I think ada berapa orang kita ni? 100 lebih. For today's session, IR 2024. So I may already explain long explanation on an overview lah on our topics covered under IR 2024. So there's a 19 session. So this session is a PAM contract 2018. So we are going to cover, I think, one of the last topic in our session, in our program. So like Amy said, we know each other many years ago. It's all because we have study group together last time, and after we both passed the exam, then we share our knowledge lah, our experience knowledge through this program lah, webinar session. And okay, so before that, I introduce myself. My name is Architect Muhammad Fakri Rahman from Fakri Rahman Architect, my own sole firm. And apart from this, I also got a few sharing program and teaching with PAM. Last 3 weeks with PAM, we have professional classes, and also with BEAR. There's also BEAR individual group set up by colleague architect. All right, so we straight away continue our session with PAM Contract 2018. Part one. So I know today is for industry engineers. So I think my approach, my language a little bit general, not so deep, quite maybe detail at certain point, a certain topic, a certain clauses. But the idea is we try to get the whole big picture, what is PAM contract is all about lah. I think that's the gist of the session. We want everyone, engineers or QS, whoever in the industry, understand what PAM contract is all about. I think that's the general. You don't need to go so deep, maybe later after you got the whole idea of what PAM contract is all about. Then after that, you go deeper and deeper lah. All right. Okay. Okay. So today's session, we try to complete by 5 p.m. and then we have a little bit introduction. What is contract with procurement, and then of course PAM contract 2018. Part 1, there's a total of 40 clauses. And for today's session, we will go through class 1 to 24. Okay, what is contract? So I think last week you have already went through a session about Contract Act 1950. Right. So actually, our topic today, PAM contract, actually is born or based or referred to Contract Act 1950. So any contract in Malaysia, tak kisahlah PAM contract ke, you beli rumah, SMP also contract, will be based on Contract Act 1950. So there's a reference. The guidance, the reference must be based on that. Even kalau masuk court case pun, let's say lah, a project, Contract Act must be referred, must be referred. Because it's all about what? It's all about two parties. Okay. Based on Contract Act 1950, Act 136, revised 1974, what is contract? A proposal is a proposal. Proposal when accepted becomes a promise. Janji. Made between promiser, siapa yang ni, dan promisee. Dua parti lah. Okay. And it involve consideration. okay, set of promises become an agreement. An agreement enforceable by law. It must enforceable by law. If not enforceable, is considered void. So in general, a common agreement that binded by the law between two or more parties. Promise plus agreement and must be legalized become contract. That's the whole idea. Contract. Contract principles element as per Contract Act 1950 offer acceptance, compensation, consideration. Intent must have intent, agreement, consent, possible fulfillment, capability and capacity, no shortfall on both parties. The whole idea is must be fair. It must be fair. Any agreement must be agreed, must be fair. So that each parties that involved can execute whatever promises inside the agreement. In order to be legal, enforcing legally binding, all these elements have to be included inside the contract. The contract will not be enforceable if any of the above item is missing. PAM 2018. Okay, if you understand PAM contract, actually it's all about adapting the principle, allocating the risk. Bila kita project, actually we are playing with risk. Risk duit, risk time, risk physical buildings, any risk. Risk of dispute, risk of gaduh-gaduh, kan, macam-macam risk. Fair and balanced form of contract allocate the risk to appropriate party who can best manage the risk. Passing more risk unnecessarily to the contractor may not necessarily benefit the employer. If contractors cannot properly access the risk, they will price the items excessively, assuming such risk to cover themselves financially. Sometimes, unfortunately, underprice such risk which may lead to unnecessary dispute. Sebut tadi pasal dispute, also risk between the contracting party. So the whole idea lah you nak manage the risk tu. Dalam project ni kan, I think you all know lah. Bila we handle one end project, always got problem lah, pasal duit lah, pasal time lah, pasal instruction lah kan, pasal kerja, everything. Itu semua risk. Itu adalah risiko. Risiko-risiko yang kita nak manage. Kita nak manage so that it can be minimal. So, okay, of course, in project, you know lah, we have two parties agreement, employer ataupun majikan dalam bahasa dalam PAM contract we call it. Remember, for those who sit for exam, I always stress this one. Dalam contract, we are not using word client, we use word employer ataupun majikan dalam bahasa Melayu, majikan. Dan kalau contractor, kita tak panggil main contractor. Itu practice, I know lah, practice kat luar main con kan. But in contract, the word being used is employer versus contractor. This the two parties that have agreement inside PAM contract. So other than these two parties, kita tengok lah, kita ada consultants kan, architect, engineers, fellow engineers, CNS, MNE, QS, and other engineers ataupun professional lah involved, specialist dan sebagainya. So of course architect as a lead consultant lah dalam any project, a building especially. And then we have fellow consultants. So kalau you tengok roles of architect, actually our team consultants lead by architect and engineers, followed by engineers and QS. So actually in terms of roles, we are same actually. Same. We are sharing the same, but only lead by architect, right? Of course, the duties might be different. There's a set that the architect to sign, not engineer, of course lah. But the overall idea is the whole team, we are team, right? The team have roles, lead by architect. What is our architect? What is the roles of architect in PAM contract? There are three major roles. As administrator, as employer's agent to safeguard employer's right and advise the employer in fulfilling contractual obligations according to contract provisions. Number two is certifier. Anything that related to cert, we are as independent certifier to act impartially in certifying conformity to construction drawings, specs, condition of contract, or any cert requirement under the contract. And also we are the quasi-arbitrator. Quasi-arbitrator ni is not arbitrator lah. It's like partly or partly as our role as arbitrator. We are referee to discharge his professional duties in quasi-judicial capacity. cost itu sebahagian lah kan, quarter kan, berapa quarter tu. Sebahagian timely and impartial manner to comply with the procedural requirement under the contract, right? So kita ni ref, itu role besar kita lah, ex architect and ex consultant. Conditions of contract, okay, this PEM contract 2018 ni, kalau kita tengok, dia adalah conditions of contract. Itulah yang dalam series of promises, series of agreement. This is, we call it COC, conditions of contract. More procedural in terms of notice requirements and time limit, provide more grounds for possible dispute, if any, may increase unnecessary exposure of consultants being liable for negligence as contract administrator. Right? Okay, understanding construction contract in the local construction scene, dominant entities, organization members utilize their own contract form to execute the project. These are known as standard form. Ingat kita dalam kontrak ada PEM contract is one of those standard form. But other than that, we also have, of course, PEM contract, PEM 2006, 2018 for the building works, private work. Other than that, we have JKR 203 or 203A, and we have CIDB, 2000, engineers, fellow engineers. You also have your IEM condition of contract for civil, subcontract for civil, and also for MNE. But generally, and then other form of contract, we have FIDIC, International Works, ICE, Institution of Civil Engineers. But normally, in Malaysia, generally, we always refer at PEM contract lah, because to be fair, you must understand, architect that draft the contract based on our role, we expect to be referee kan tadi kan, to be fair to the parties involved. If you use JKR, of course, the contract little bit biased to JKR. If you based on CIDB, of course, that contract little bit biased to contractors. So that's why they normally use PEM lah, normally use PEM for building works, for building works. All right, some the big history of PEM contract. So PEM contract is actually based on RIBA, JCT 1963. And then we have PEM ISM 69. That's the first version of PEM contract. And then we have updated version 1998. And then PEM 2006, quite a long time ago. I mean, long usage of PEM 2006. And then the latest version is, updated version is PEM 2018 lah. If you look at, I think most of project, even currently, they are still using PEM 2006, most of them lah. But actually slowly they started to adapt or to adapt with PEM 2018. Later we show lah what's a little bit different. Actually, it's not so much different, but here and there got some amendment lah and updated. So one, okay, we have JKR, we have PEM, we have CIDB, but PEM contract itself, we have three lah. That's the major, the major. Of course, there are other small works, all those things, but we are focused on these three. We have PEM contract with quantity and without quantities. Later kita akan tengok apa beza dia. And then we have PEM subcontract, NSC or nominated subcontractor or nominated supplier. It's between NSC and contractor. That's our main contract lah. Okay, just a little bit. What is the difference between contract with and without quantities? Number one, definition of work. With quantities ni simple. Kalau with quantities simple, senang lah. Drawing and BQ. Kalau without quantities, no BQ. Only specs and drawings. That's the major difference lah. Dan juga perkataan-perkataan yang guna lah. Kalau dalam with quantities, ada architect and QS. Kalau without quantities, architect saja. That's the major ni lah. QS is optional. You still can use QS if you want, but it's not compulsory lah for without quantities. Measurement with quantities by QS, without quantities, architect is enough. Then the rest you can rate common basis, not required for evaluation. Evaluation and variation, rate MBQ based evaluation, without quantities, schedule on rates. Changes to BQ will result VO. change to drawing was result VO. So simple lah. With quantities, we have drawings and BQ. Without quantities, we have drawings only. Alright. Okay. So that's general what is PAM contract lah. Okay, what is procurement? Procurement kalau bahasa Melayu ni kita panggil dia perolehan lah. Because some people still lagi pening. PAM contract ni apa kan? Procurement tu apa? Tender tu apa kan? Especially yang mana yang baru lah, yang baru dalam industri. Perolehan tu apa? Tender, PMC, dah pening kan? Datang pula turnkey, apa ni? Simple, procurement tu perolehan. Perolehan tu ialah cara projek tu, okay, what is procurement? The process of bringing buildings or projects into existence and includes all the activities required to achieve that objective. That's general ni lah. Method of procurement is the principal contractual arrangement used in project. Cara dia macam mana? It can be traditional way, which is we call it conventional lah. Traditional client and architect commission, dan lepas tu kita panggil tender lah. Ataupun it can be project management contract, or it can be in design build, in the form of design build, or it can be turnkey contracts. Delivery method, the way of delivering, producing the building within the total procurement process. See, what entails a contract document? Kan, kalau projek tu contoh di tender, dia mesti ada contract document. Tender document lah. Kalau biasa kita kalau tender document lah. Tapi bila dah what contract document lah. As per PAM 6 or 18 clause 3, this is the list. So ada contract drawings, ada specification, they have descriptive of schedules, the schedule of rates from the tender, LOA, some of tender. Then one of them inside the contract document is condition of contract. Nah, inilah dia PAM contract. So dalam tender document tu, PAM contract is part of the tender contract document. Nah, itu kena faham. Di mana duduk je PAM contract ni. PAM contract ni lah perjanjian kita tu lah. Perjanjian kita tu kat situ. Kalau kata kita buat perjanjian dengan orang, COC is our agreement. Dan part of contract document. So ada macam-macam, ada drawing kan, ada specification, ada schedule of rates, and so on. LOA pun kat sini. Okay, a little bit what is tender. Kalau projek konvensional kita kata tender lah. Ini basic sequence lah. We have pre-queue, invitation tender, site visit, tender document collection, and then we have tender submission, tender evaluation, tender nego, and sampailah kita award lah. So a little bit explanation, pre-queue, and I think you know lah, kalau pre-queue ni sometimes client they expect you to submit first filtering system ni lah. Just give basic information on your company, and then before you been shortlisted lah. Normally like that lah. You call it pre-queue kan. Tenders are selected, shortlisted based on certain preset conditions or guidance or requirement. Contractors, class of contractors, blah 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 lah. Invitation to tender, qualified tenderers are invited via public notice. It can be form tender ni, you can be open tender, it can be selected tenders. Itu depend pada client lah, right? And then we have a site visit lah. After that, we have site visit to all the tenderers. Then we have tender document collection, date and place to collect, and then tender submission, and what is the requirement or documents needed to submit, the date, and the deadline, or so on. Tender evaluation, you have tender interview, clarification, tender negotiation. Of course, this one we start involve consultant, architect, QS, M&E. We will help client to evaluate the tender, recommend to the client, and then after we recommend, we award lah. Right, this basic sequence of the tender process. So just now we already apa itu procurement kan? So this is the list lah, one of the list lah. Banyak sebenarnya. So yang normal yang kita biasa buat ialah conventional contract lah. Conventional maksudnya kita ada client yang appoint team of consultants. Okay, I want you to design, let's say school for example. Kita pun buatlah design kan, design detail, buat submission, and kita prepare tender documents, tender drawings, then kita pun tender, right? So tender yang tadilah proses tu, tender bla bla bla, that award. Itu adalah conventional. So kat situlah duduknya plan contract kalau kita guna plan contract lah. Kan? Dalam tender document tu, one of them is plan contract. Just for our understanding lah. Apart from that, we have PMC, we have construction management, we have design build, turnkey, dan normally projek ni takkan guna plan contract. Dia tak guna. Plan contract hanya guna dekat conventional je. Contohnya macam design build. Macam JKR kan. JKR dia dah ada dia sendiri. Dia punya form untuk design build. So, dia takkan guna plan contract. Alright. So, traditional conventional, I think you all know, okay, must be, tadi ada explain client, dia akan appoint consultants, lead by architect. After kita dah siap kerja semua, tender apa semua, then kita akan award. Kalau dah tender process all those things, and then kita akan award kepada contractor. Normally, kita kata dalam awarded the contract to the contractor, kita panggil dia fixed lump sum. Dalam kontrak pun sebut the plan contract, the contract is lump sum actually. The fixed lump sum dipanggil. Why lump sum? Because actually all cost plus. Cost plus ni kalau you nanti I explain. But fixed lump sum ni actually contohnya apa? Contohnya let's say you suruh buat feature wall contoh. Feature wall tu dalam BQ, dalam you punya tender, you akan ada drawings, you ada BQ kan. BQ tu you akan ada rates kan. Contohnya feature wall tu ialah okay, to construct or build feature wall blah 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 blah. Kan? You pun leave it to contractor to price in. You takkan tahu berapa detail, contohnya dia pakai tiles, berapa harga skirting tiles, tak tahu pun. Tapi yang you tahu apa? The total price rate untuk tu you tahu. Contohlah RM10 sekaki ke contoh, dan you akan dapat total harga for that particular feature wall is say 50k contoh. Yang you tahu, okay, we agree that you will construct the feature wall based on 50k. You don't care about harga pekerja dia berapa, you tak peduli pun pasal harga skirting tile dia pun tak. You hanya tahu total cost. Itu kita panggil fixed lump sum. Actually, contract kita is fixed lump sum. Kalau cost plus ni ialah you ada basic price, contohnya harga barang, dan juga price mungkin dari segi daily punya cost, workman punya cost, kan? Dan juga any additional cost lah. Dan you akan dapat total price for that. Which is kita jarang-jarang sangat guna lah cost plus ni. Kan? Jarang sangat guna pasal cost plus ni. So, ni traditional. Then we have project management. You tahu lah PMC lah. So, actually dia hampir sama je dengan conventional. Tinggal lagi between consultants and client, kita ada PMC lah, project manager. Project manager. Biasanya, kalau biasa guna term yang kita guna, PMC ni biasanya macam postman lah. Dia link between client and consultants. But dari segi project, masih sama. PMC ni jadi reference person lah for the project. Tapi, our obligation, our responsibility still same. Architect, engineers, planner, our responsibility, our liability remain the same. Project management, PMC ni hanya they manage, you help us to manage project saja. That's all. And then we have design build and turnkey. Design build, I think you know lah, is a client appoint contractor, okay, to execute any job, kan? Any job based on client needs. Biasanya client mungkin dah ada dah needs dia nak bilik besar tu, dia nak ni ataupun certain requirement dia kan, dia dah ada. Jadi tinggal lagi contractor appoint all the consultants. So our majikan, our employer is not employer, the real employer. Our majikan, our employer is contractor for the design build. So dia ada beza dengan turnkey. Nanti kita turnkey dia nampak sama tapi tak serupa dengan turnkey. When we have also innovation. Innovation ni bahasa mudah dia lah kahwin. Innovate. Dia akan divide into two stage or two parts. At the planning stage, client akan appoint consultants as usual. Okay, you appoint architect, you appoint consultant, QS, all those at the planning stage. But at the construction stage, dia akan appoint macam design and build. So that kita akan dibawa atau dipark under contractor. That's what we call innovation. Dia macam kahwin lah. Dikahwinkan sistem conventional dan sistem design build. This innovation. Okay, turnkey. Turnkey ni dia actually dia nampak sama macam design build. Tapi berbeza. Beza dia apa? Kalau design build, dari segi progress of work dia hampir sama. Tapi beza dia lah, turnkey ni normally projek government lah biasa. Ialah nama pun turnkey. They expect you bagi that contractor, you do everything lah. You do everything. Design, spec, semua you buat, you propose. Sampai you bagi I key saja. For me to turn the key. So kalau design build, projek tu masih macam konvensional. Maksudnya dari segi financial, bayaran, payment masih lagi daripada klien atau employer. Dia masih bayar. Kontraktor claim macam biasa. Dia siap kerja, kita bayar. Progress payment kan. But for turnkey ni kontraktor buat semua. Termasuk dia punya financing. Dia provide semua. Dah siap projek, barulah klien bayar. So maksudnya kontraktor akan prepare everything. Dia akan prepare design brief, dia akan prepare consultants, dia akan prepare apa lagi? Everything. Floor area contoh hospital kan. The idea ialah turnkey ni kerajaan ataupun klien dia tak ada kepakaran normally. Satu, dia tak ada kepakaran, so dia leave it to industry, kontraktor lah. Dan dia nak cepat. Biasanya nak cepat, okay, I tak tahu, I tak peduli, I nak you buat semua ni. I tahu I dapat kunci, siap everything. Dan of course lah, along the road adalah proses tu. Kontraktor masih lagi present daripada klien tu kan, to get approval for the design for example. But everything will client leave it to the kontraktor. That's the basic idea lah for understanding kita punya procurement. Jadi apa pun procurement ni related to prime contract ialah conventional. This one is just for your knowledge lah, general knowledge. Okay, PAM contract 2018 with quantities. Again, this is the document kan, cover depan lah, cover depan PAM contract tu yang you boleh beli dekat PAM kan, dia ada hard copy. So balik revisit balik, PAM contract ni adalah part of contract documents. All the guides, all the promises, all the tanggungjawab, all the scope of work, what do, what don'ts by contractor, especially architect, for example, consultant dan so on. Semuanya ada dalam tu, the scope of work. Alright. So if you read PAM contract, they have the structure lah, the structure of the PAM contract. Yeah, of course, you have front page, just now front page. Then they have articles of agreement, 1 sampai 8, 1 to 8. Article 1 to 6 is they're talking about contractor obligation, contract sum, and consultants. List of consultants that involved. Mainly biasanya ni lah, architect kan, engineers, MCNS, MAD, and QS, and specialists, if there's any lah. Article 7 is so important. They're talking about definitions. Apa-apa definition you nak tahu kan, pasal professional sum ke, NSC ke, semua ada dalam tu. The meaning, the definitions. Article 8, meaning to qualification of words, and then agreement signing page. Alright. And then the condition of contract, we have actually, okay, for this 2018, we have 40 clauses. 40 clauses. This one based on 2006. 40 clauses. Then we have appendix. Appendix also important. You must know, because appendix, the append, the list of certain info. Contohnya date of completion, the amount of DLP, form bond, dan so on. Ada information, sectional completion dan sebagainya. Okay. Article of agreement. Kat depan Article 1, contractor's obligation is very important because they highlight the obligations of contractor. Primarily, the contractor obligation to carry out and complete the works subject to condition. So you can tie back with clause 1 nanti. Klausa 1. You baca, you can tie back lah. Klausa 1 is contractor's obligation. Article 2, contract sum. Primary obligation of the employer is to pay contractor at the times and in manner specified in the contract. You can refer back clause 13. Clause contract sum ni jumlah harga projek tu lah. Contract sum panggil. Again, article 3 to 6 define the roles, siapa consultant tu, siapa architect, kan? Because this is the person yang involved sebagai if related to authority, this is the PSP and SP lah. Related to contract, ni adalah consultants lah. Alright. Article 7 definitions, tadi dah sebut. Alright. Okay, this is the agreement. So this agreement is made, that's how you to fill the agreement lah. So you can see it's between employer and contractor. Here, this agreement is made, blah, 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 date, then the name, and then the address, important. Here, after call employer, not client, not apa-apa lain, dia mesti nama dia employer. And ABC contractor, alamat sekian. Here in after call the contractor, not main contractor, not main con, and so on. So if you sit for your exam, tak kisahlah exam apa, architect, engineers, please use the right word. So it reflect that you know the right word lah when you call a certain person inside the contract. Sama juga arkitek. Arkitek yang menggunakan SO pula. SO ni projek JKR je. Kan? Superintendent officer. Guna kata arkitek lah. Engineer lah. QS lah. Alright. Whereas the employer is there, cadangan membina dan menyiapkan sebuah banglo, contohlah banglo 3 tingkat, called works. So projek kita ni, any projek dalam kontrak, nilai dia let's say 10 million contoh. Dia adalah works. Dia adalah works. Total works. Total kerja tu adalah works panggil. Works nanti you akan tengok dekat definition. Has cost, drawings and contract bill showing and describing the work to be done to be prepared by his architect and consultant. And whereas the contractor has supplied the employer with fully price copy of the said contract bills. And whereas the said drawings numbered, blah, blah, blah. Semua ada. Inclusive data referred to as the contract drawings. Kita tak panggil construction drawing, kita tak panggil detail drawing. Dalam kontrak, kita tak panggil nama lain. Kita guna contract drawing je sebenarnya. Actually, dalam PEM contract, the right word ialah contract drawings. Kita tak guna construction drawing pun. Itu nak panggilan kat luar. Yang kita praktis kat luar, biasa buat kan. Nanti kita sentuhlah apa itu construction drawing, apa itu drawing. Tapi dalam kontrak kita contract drawing. Because contract drawing actually must be equal to contract document yang you tender tu. Sepatutnya. Whatever yang you tender drawing kan. The drawing contohnya, for example, architect must equal to drawing yang you beri pada contractor masa construction. You tak boleh memandai-mandai menambah benda baru. Ni kena faham lah. Kan, kontrak dia ada possibility untuk jadi variation lah. Atau VO lah, bahasa kasar kita kan. Kata VO. Sebab dia must be same drawings. Kalau ada drawing lain you nak tambah, then kita akan panggil nama lain. Further detail drawings. But the basic drawing yang you issue, mula-mula nanti kita tengok clause dia yang berkaitan. Kita panggil dia contract drawings. Okay, this is the main structure. Okay, actually I previously I selalu explain lah. Kalau you baca PEM contract tu, dia ada 40 clauses. PEM 2018. 40 clauses. Actually this one is based on 2006. Tapi nanti I explain lah the beza dia. For today's session, kita akan cover clause 1 sampai 24. 24. But if you read the PEM contract tu, you tengok kat dia punya tajuk depan tu kan. You can segmented or divide all the classes in this way. This is how I divide lah. Okay. For example, class 1 to 10 actually is all about, I call it prelim matters. An item that you talk at the early stage of project normally lah. That's why they put at the front. For example, contractor's obligation, tanggungjawab contractor. AI, the instruction form by architect. Contract documents, program and split drawings, level, setting out. Ni semua awal-awal ni. Awal masa you start kick off meeting kan, you cerita. Materials, goods and quality, you remind the contractor. Royalty, intellectual properties, site agent, site staff. Site agent tu wakil contractor lah. Project manager biasanya. Site staff ni biasanya IOW lah, atau CW atau project resident architect sebagainya, dipanggil on site. And class 11 to 20, I call it the core matters. Why am I core matter? Because without this, in principle, without this, project tu tak boleh jalan. Contohlah, it's very important. For example, VO is important. Contract bills, of course, contract sum, amount of money, material and goods, the quality of the materials. You're talking about CPC 15, completion. You're talking about project ni tak boleh Alibaba. Important. You tak boleh total sub. And also you're talking about insurance. Insurance is very important project. Tak ada insurance, project tu as good as tak boleh jalan lah. Dalam konteks sekarang kita, insurance is very important. Then we have clause 21. It's a standalone clause because related to date, date of commencement, postponement, and completion date. And then we have 22 to 39, klausa 22 sampai 29. I call it supplementary matters. Why? Because these clauses actually dia hanya wujud bila you diperlukan dia je. You ada masalah, you perlukan dia, only you guna. For example, clause 22, you're talking about LD. LD ni takkan ada kalau projek tak delay. Kan? For example juga, EOT 23. Projek tak delay, tak adalah EOT. You don't talk about EOT. Determination, penamatan employment of contractors. Kalau projek itu tak ada masalah, tak ada isu, tak ada gaduh-gaduh apa, you tak akan determine. Sama juga NSC. NSC ni, you hanya perlukan NSC, you only require NSC when the project really need. Of course lah. Because there's a project, you don't need NSC pun. Because contractor can do everything. So it's like supplement the core tadi tu. Okay, and then you have clause 30. Clause 30 is tadi kalau 21 pasal time, 30 pasal duit, money, payment. Payment is a standalone clause yang panjang, yang ada clause sub-clause yang panjang. They are also important. That's why duit ni dalam kontrak is very important because kita nak bayar kontraktor ni. Tak ada bayaran, tak ada kerja. Okay, work done. And then we have etc. 31 until 40 actually. Okay, nanti this one I let now. This is 31, 38 yang tengok ni ialah based on PAM 2006. If you compare side by side PAM 2006 and 2018 dari segi arrangement of clauses, semuanya sama daripada clause 1 sampai clause 33. Yang berbeza ialah 34 sampai 40. Because why? 34 dalam PAM 2006, this one is PAM 2006, dia combine adjudication and arbitration for dispute. And then you have 35 mediation. Whereas dalam PAM 2018, you have 34 start with mediation. Okay, start with mediation, not adjudication. Start with mediation, and you have 35 expert determination. It's a new clause. Expert determination. And you have 36, 37, di mana you dipecahkan education satu clause, arbitration satu clause. Satu tambah clause baru, satu lagi dipecahkan. Education dengan arbitration dibuat dua clause. And the rest they continue balik. Notice, from bond, and law. Itu je dari segi arrangement of clause. Menjadikan dia 40 lah. But the rest actually sama dari segi. Cuma dalam tu ada beza lah. Nanti akan kita touch lebih lah. Dia punya here and there punya amendments. Alright. So today kita akan go through clause 1 until 24 lah. Okay. Ni tadi just little bit explanation lah. What is perimeters, what is core-matters, date, supplementary matters, cert, clause 30, and etc. Okay, because this is slide, I make it like a slide notes. So I'm using quite thorough the short form lah. For example, macam kalau you jumpa employer tu, E tu employer lah. Kalau architect, ER for architect, ENGR for engineers, QS, you know lah. Cons for consultant, C or MC for contractor. So takut confuse nanti. Okay, you tengok clause, kita start with clause 1. Clause 1 ni awal-awal lagi dia cerita lah pasal tanggungjawab contractors, contractors obligations. Clause 1, 1.1, completion of works in accordance with contract document. Clause 1 dia cerita pasal contractor kena buat kerja ikut kontrak. Simple as that. Tanggungjawab satu sekali, paling besar sekali kan. Contractor have to complete the works accordance to contract. Okay, 1.2, they talk about temporary works. When contractor, you tahulah, contractor bila dia buat kerja, dia nak buat satu kerja hakiki dia tu, dia perlukan additional works to build that. For example, staging kan. For example, whatever lah, any temporary works required. So this one is talking about temporary works. So everything must be under contractor punya tanggungjawab lah, temporary works. You kena ingat, kerja projek ni bukan bangunan tu saja, kan? Dia ada temporary works, nak bina tu. So temporary work tu ialah tanggungjawab contractor. 1.3, contractors design and responsibility. There's a case where bukan semua design yang diguna consultant punya design. Kan, biasalah, sometimes they use their design. either by contractors, and they can counter propose lah normally. Depend. If contractor choose to submit alternative design, such work are fit for its purpose. Maksudnya dia must lagi fulfill any requirement, details or design requirement as per contract lah. But it doesn't mean that it's a design and build of whole works. Tak. Walaupun contractor to counter propose whatever design, dia simplify design you ke whatever, tidak bermaksud dia design and build. Dia tidak masuk design and build. And 1.4, we are talking about discrepancy yang occur during construction lah. Contractor give architect a written notice if there's a discrepancy, architect to instruct to plan the works prior to execution lah. Impose obligation to plan thus produce lead request for info to resolve discrepancies. Architect respond in period not to delay works. So ingatlah, discrepancy ni, of course, normally kita ada drawing architect kan, kita drawing engineers, biasa je lah. When you issue both drawing, sometimes biasalah kadang-kadang ada discrepancy kan, engineer punya tiang terbesar sikit. So contractor still have responsibility to highlight any discrepancy. Dia tak boleh terus buat je, tak boleh. Contractor mesti lagi ada tanggungjawab untuk memeriksa, menyemak both drawings, and then superimpose ke whatever lah. Dia masih ada tanggungjawab tu, because they are the party that going to build the buildings. Okay, class 2. We're talking about architect instruction. This is the most powerful document issued by architect on site. Kalau architect dalam ni dia tak ada engineer instruction, dia ada architect instruction. What does that mean? In terms of weight, let's say that works involve engineer's work. Engineer akan issue engineer's instruction, but must covered by architect instruction. So, because engineer instruction bukanlah kata tak valid, tak ada weight as strong as AI. AI ni the most powerful lah, powerful instruction form dalam contract. The contract shall subject to clause 2.2 AI and 2.3 provisions empowering instruction comply with all instruction issued to him by architect in regard to any matter in respect of which the architect is expressly empowered by this condition to issue instruction. Explanation: this clause strictly empower the architect to issue AI to main contractor. Very powerful. The AI issued must be expressly empowered by the condition of contract. Okay, contractor having received AI must comply with the instruction. Simple. Contractor dapat, dia kena buat je tu. Tapi of course lah, ada syarat-syarat dia lah. Kita tengok dia. Instruction shall be in writing expressly entitled architect AI, architect instruction. Kita ada tu. Kena ada. Others form of written instruction, including drawing issued by the architect, shall be NI. Okay. Written confirmation from contractor, CEI, or confirmation of the instruction by architect with an AI. So contractor pun dia boleh any instruction dia boleh confirmkan dengan CAI, confirmation of architect instruction, because dia nak confirm, dia nak double confirm the instructions. Provisions empowering instruction. This is the provision. Tadi the basis dia adalah any instruction from architect, contractor must deliver, must execute kan. But of course it must be based on this clause. This clause 2.3, upon receive a written instruction from architect, the contractor may request the architect to specify in writing which provision of the conditions empowers the issuance of said instruction. Dia boleh tanya lah. Dia boleh tak soal, dia boleh tanya. Kat mana ni? Whatever, dia boleh tanya. The architect shall forthwith comply with such request. If there's a request from contractor, kita kena comply lah. Architect kena comply. If the contractor thereafter complies with the said instruction without invoking any dispute, dia tak ada highlight pasal dispute ke apa, proceed under contract to establish the architect power in that regard, the instruction shall be deemed to have been duly given under the specified provision. So maksudnya, in principle, AI once architect issue, contractor kena buat. Itu principle. Tapi ada ruang, ada contractor have right and some sort of like question lah, like question like asking, like asking architect kat mana duduk ni, based on what you issue ni, issue AI dia pelik ni, for example lah, quite pelik ni instruction ni, contoh lah. So architect kalau rasa pelik tu, dia kena explain lah, dia kena answer any contractors punya request, right? So short note apa? Short note, the architect power, the power tu to issue instruction is limited. Dia bukan apa infinity to the type of instruction expressly identified in the contract. Of course, that instruction must be within the contract lah. You jangan kata this is AI, contractor to supply 2 nose Ferrari car. Tak boleh lah kan. Sebab kereta Ferrari tak ada dalam kontrak. Contoh. Zirit lah. Contoh. So, must be within the contract punya conditions. So, if you found out the words in the contract, normally they use shall or may. It's different. Shall, dia punya weight little bit ke arah mewajibkan. It's not must, but ke arah must. Dia punya weight tu lebih berat. Architect shall, dia punya weight tu lebih kuat. But kalau may ni dia low sikit, dia lembut sikit. Dia ke arah mungkin kan. This contoh lah. This is an example or inside the COC, the related clauses that provision architect shall give AI. Related AI lah. Provision architect may give AI. You boleh baca 1.4 related to discrepancy, 4.3 deconforming with the laws, etc. lah. For example, architect may give AI related to further drawings or details, setting out errors need not to be rectified. Okay, maybe clause 31.4 postponement or suspension of all any parts of works, for example. Okay, architect instruction 2.4 tadi we talk about AI issue, and then in the event that contractor fails, if the time compliance which shall not less than 7 days from receipt of the AI is stated by architect in the AI and the contractor does not comply without prejudice to any other rights and abilities which he may possess under contract, employer employ and pay other persons. Third party lah. Biasanya kita panggil third party kan. Other person. Dalam kontrak dia guna perkataan other person. To execute any work which may be necessary to give effect to such instruction. So let's say you dah bagi AI, dalam masa 7 hari kontraktor tak buat. So the right of employee lah, dia boleh ambil online. Dia boleh cari online untuk buat kerja tu. Third party because kontraktor tak buat lah. The kontraktor is not comply with the AI issued by architect. Okay. The cost of employing other person and additional cost, this correction shall be set off. Biasanya kalau ada third party ni, ada person, dia akan tie balik dengan set off. You kena ingat tu. Kalau ada je, mesti ada je tu. Third party set off. Because apa? Cost nak suruh orang buat tu, that other person to do the works, the cost will be set off from the contractors money lah. Under clause 30.4. Later, under clause 30 kita akan tengok lah apa itu set off ni. Start notes. If the contractor don't follow AI within specified time, contractor breach contract. Some sort of breach contract lah. Because you dah bagi tahu lah 7 hari kan. 7 hari. Minimum specified time is 7 days. For specified time less than 7 days, only apply for clause 4.1. Jadi requirements. Employer shall have the right to employ other person under the term and procedure of set off. The set off procedure shall refer to clause 30.4. You kena ingat dalam kontrak compliance with AI ni, this stated 7 days. But we bit off a bit from exam lah. In reality, kadang-kadang ada kerja-kerja yang required more than 7 days. That's how and where you as architect or consultants must be fair lah. Kadang-kadang lah, because you kena faham, project ni, you know, this time contract is applicable for any type of project, any size of project. Sekecil-kecil banglo, sebesar-besar airport, for example. Imagine, your AI tu, instruction for that particular job, untuk banglo, buat, say, instruction untuk buat lantai, ataupun coping, for example. Coping tu, sehari settle kan. But you compare versus you give instruction for airport in scope of work. Kan? Besar. Kalau you rasa kerja tu memang 7 hari tak sampai siap, you must be fair lah. So, it's okay actually for you to, instead of 7 days, tapi beritahu lah. You must comply. Instead of 7 days, you comply within, say, 14 days, for example, because the works require more time. It's okay. But of course, for exam, you just follow whatever stated in the COC for exam. Itu je prinsip dia. Of course, pasal time ni, actually ada kelonggaran lah sebenarnya. Contoh macam you buat schedule defects. You buat schedule defects untuk airport, mestilah lah you need more time contractor to rectify. Instead of 28 hari, mungkin more. So that's the thing that we can discuss lah. Okay, with the contractor, or you can update inside the COC kan, with the employer's approval lah, agreement lah. Employer shall have the right to employ other person under term. Okay, ni tadi set off. So important lah, timeline 7 days tu buat timeline. Okay, contract documents. Tadi kita sebut pasal contract documents, contract drawing and so on. Contract documents, forget the drawings. Contract documents dalam class 3, dan you pun boleh tengok dalam definition pun ada contract document apa, what it entails. The priority order of interpretation, what does that means? A, letter of award. You ada articles of agreement, you ada COC. COC ni lah pengontrak ni. Contract drawings, contract bills, other document incorporated in contract document. The sequence highlight the priority. I mean, who take precedence? For example, ada discrepancy antara drawing dan BQ. Who take precedence? Based on this, drawing will take precedence because drawing is above the contract bills. For example. So there's hierarchy. Dia memang sebut dalam kontrak macam tu. 3.2, original copy in custody of architect OKS. Okay. 3.3. Ni important. Architect QS immediately after project start. After project start, to provide contractor within 14 days. 2 minggu je. 2 copy contract drawings. Bukan construction drawing, bukan detail drawing, contract drawing. Okay. 2 copy unpriced BQ. Then to provide contractor 1 copy signed contract document within 40 days after work start. Ini yang biru ni lah, actually is updated based on 2018. Kalau tengok 2006 tak ada ni, yang biru ni. So ini yang cakap tadi, contract drawing sepatutnya adalah same drawings yang you guna masa tender drawing tu, tender document tu, you prepare tender tu, must be same. You tukar tajuk je, contract drawing. Because that drawing, actually the same drawing contractor price in. Kalau you issue drawing tu sebagai construction drawing, yang you dah tukar-tukar, you tambah itu, tak boleh. It's not fair to contractor. It's not fair. That's why important, any project, practice please. Tender tu dah complete dah. Ataupun sekurang-kurangnya, contohlah, kalau ni practice lah, contohlah, you tak sempat sangat buat drawing, make sure item tu ada. Ada you sebut dalam drawing atau dalam BQ. Ada betul. Contohnya you tak sempat buat schedule. Contohlah, for example, you tak sempat buat schedule, drawing. Tak sempat sangat lah ni. Make sure lah ada item tu, tingkap spek dia apa, aluminium ke apa semua, size dia kena ada lah. At least QS pick up sekurang-kurangnya. Kan, at least ada. That's the key lah. Then you will come to 3.4. Further drawings or details. Inilah yang kita panggil dia, kalau dalam praktis, kita kata dia sebagai construction drawing. Because apart from contract drawing as your main reference as your drawing for construction, you boleh supply to the drawings or details to contractor. Ini yang kita panggil construction drawing, di mana drawing ni lebih kepada to help contractor to further enhance, to further clarify the contractor, to help them to proceed or execute the works. We can provide, no problem. Ni simpan detail drawing kat sini lah. Ni kelas je. 3.4. Details drawing, 3D drawing, you buat blow up 3D drawing ke kan, animation, whatever. Kat sini. This tapi without changing or without adding or whatever to the original contract yang ada dalam contract drawing tadi. Ini important. You tak boleh lah, tiba you bagi detail drawing baru, detail tu dalam contract drawing tak ada pun, tapi mana-mana tambah. Because dia akan lead to VO atau variation. Okay. 3.5 work program. Contractor to provide 6 copies within 21 days from receipt of letter of award for his information. Not approval lah. Remember. Not approval. Hanya untuk information. To show order of the work sequence, architect may instruct contractor to revise if you got comment lah. You boleh comment. May instruct. Ingat, instruct ni kalau dalam kontrak, dia akan biasa relate dengan AI. Instruct je AI. Instruct AI. 3.6, work program not part of contract document. Not any part of contract, whether or not, is considered part of contract document. Work program ni. Work program is not part of the contract document. Why? Earlier clause stated that they just to show order of works and order of contractor punya work. We cannot force contractors on how to do works. We leave it to them. For example, dalam program dia kata dia siapkan rumah sampah, contohlah dalam bulan kedua, contoh rumah sampah bulan kedua. Suddenly they change plan because rumah sampah ni kacau lah, dia punya escalation. I cannot now, I must do it later, for example. Then he change. Dia buat rumah sampah tu dalam bulan ke-7 contohnya. Just because of that, kalau you imagine if the program is part of contract document, by the time they change the rumah sampah punya time tu, habis di dalam kontrak lah. Cannot. That's why we cannot buat work program as part of contract document, because we leave it to contractor to arrange the way they execute the work on site. That's the idea. Tapi yang penting apa? Yang penting completion date tu adalah. Of course, that's why bila arkitek dapat work program, is for us as to help us monitoring the works. Contohnya dia kata rumah sampah bulan 2. Suddenly dia pun update, revise. Bulan 6 rumah sampah. So dia kena update lah, beritahu lah. They must update us, consultants. 3.7, architect acceptance of program. Acceptance by architect not relieve contractor from any obligation. Architect may use for monitoring. Ingat, for monitoring, for EOT assessment, we may use. Right. 3.8, availability of documents to keep copy of contract drawings and unpriced. This one explanation lah. 3.9 also explanation contract document in class 2.1 only to be for this contract. Explanation lah. Dia tak boleh guna untuk projek lain. Okay. 3.10 as built. Okay, ni pun penting. Dalam kontrak as built sebenarnya, I know kita punya practice sometimes as built ni kita bagi lambat kan. Tapi you ingat dalam pen kontrak actually as built and O&M must be given before CPC. Actually, sebenarnya ramai tak tahu ni. Barat kena before CPC because it's part of CPC issuance, the document. Without as built, CPC tak boleh issue. By right. Important. No CPC without as built. Okay, class 4, statutory obligations, notice, fees and charges. Okay, this one is all related to any statutory or authority requirement during construction lah. That must be comply and abide by contractor. Of course lah, masa you buat projek tu kadang-kadang ada instruction ataupun requirement for authority. 4.1, statutory requirement to comply and submit notice required by any applicable law in respect of works and term works. Kalau ada lah, kena submit notice. 4.2, inconsistencies with statutory requirement. If contractor found inconsistencies, contractor to give architect written notice. Kena highlight lah. Kalau ada jumpa something that tak tally dengan authority punya requirement, contractor kena highlight pada architect lah before commence any work. That's contractor responsibilities. 4.3, conforming to statutory obligation if within 7 days contractor not receive AI for that particular works. Okay, contractor boleh proceed sebab itu adalah keperluan authority and deemed as VO. Consider VO lah kalau memang authority punya issue. 4.4, fees, levies or charges shall pay and indemnify employer any fees, levies or charges or penalties. If contractor fail, employer may set off. Right? Okay, clause 5, levels and setting out of the works. Architect set it out. Ini penting. It's very important. Architect related to setting out before contractor start works. Okay, dia punya flow simple je. Before contractor start setting out, all information must be given by architect or consultant lah. Okay, architect to determine levels, to provide drawings, to show the dimensions in the drawings. Okay, we give all information, we supply all information. But contractor to rectify any error at own cost. If there's any error, for example, contractor masih tanggungjawab, dia dapat info tu, dia mesti upon surveyor. Surveyor masih bawah tanggungjawab contractor. To check, to double confirm betul ke tidak ni tally dengan setback, dengan boundaries, itu masih lagi tanggungjawab contractor. Mana contractor punya responsibilities. Kalau ada error, contractor kena rectify, kan? At own cost. Architect may accept error if there's error lah, with consent of employer, subject to deduction. Okay. Ni clause 6 pun penting juga. This clause is related to materials, the quality of works, workmanship, and so on, on confirming the quality of works. Either you do testing, you do inspection, you buat mock-up dan sebagainya. This is the clause. Ni okay, 6.1. Standard of works, materials, workmanship and goods shall be as per standard described in contract. Kalau kontrak itu sebut kena ada QLASIC lah. Contoh. Kalau as per whatever standard, you boleh masukkan. SIRIM ke, you nak ikut standard UK ke, whatever lah, MS ke, boleh masukkan. As part of kita punya contract document. Okay. Because that one will set the benchmark and our reference when we talking about the quality of works that contractor must do, must carry out on site. 6.2, production of vouchers, of course. Bila contractor buat kerja, dia mesti ada by request of architect to produce evidence lah, to prove the compliance to 6.1, brochure ke, kan, whatever lah, SIRIM punya ni ke. Okay. 6.3, inspection and testing. Okay, we have right to ask or to require contractor to do some testing. Dan kontrak dia benarkan lah. This testing ni termasuklah you buat mock-up ke. Mock-up tu sebenarnya part of this lah. 6.3 mock-up, kan. To provide samples good for testing as requested by architect. Architect may instruct to open up for inspection, arrange to carry out tests or required due to prior failure of breach of contract. Okay, maksudnya apa? Architect kita boleh require, contoh you nak buat any testing, any mock-up, any apa-apa test lah. Contohlah you nak buat test apa test bumbung lah, bumbung kan. You kata bumbung ni tak kuat lah, kawasan ni kawasan berangin kuat ni. So bumbung tu I nak you buat mock-up, you buat test, ataupun you buat lab test ke, for example. I nak you buat lab test. You bagilah arah-arah macam mana kan. Kau kata, kena buat lah. Kena buat lah. Tapi ingat, any instruction you bagi buat test tu, contoh load test, kan, lab test, whatever, because you want to test the strength of the structure, for example. Cost tu akan jadi VO. Dia akan jadi variation. So, you kena bayar contractor untuk buat tu. Unless cost tu dah di-provide dalam kontrak. Dah sebut dah, okay, a contractor to provide lab test and load test, wind test, whatever lah, wind load test for roofing, blah blah blah. You dah sebut dalam kontrak. Dan tak ada VO lah. Contractor kena buat. Itu memang part of dia ni. Sama juga mock-up. You buat apa-apa mock-up, kan, fasad mock-up ke, materials mock-up ke, typical mock-up ke, boleh, tak ada masalah. Kena make sure masuk dalam kontrak. QS penting QS kena ambil tahu ni. QS with an architect must talk to each other lah. Bukan architect je, engineer. Kalau engineer rasa you need to do mock-up for structure, boleh. Ini pun salah satu. Inilah clause dia. This is the clause that related to. Semua ni takkan jadi VO kalau you tengok tu 1, 2, 3 provided in the contract base, memang dah masuk siap-siap, atau the test show that it's not according to contract. You buat test tu tengok, alamak memang betul tak ikut contract, then contractor kena tanggung lah the cost. Number 3, in opinion of architect, that test required due to prior failure. Sebab sebelum tu dah ada kegagalan, dia has failed. So okay, I want you to do this test. This test you must, the cost under you, because based on prior failure. To remember. So architect power up to date of completion only. Of course, if no discontinuity, contractor may apply EOT under 228. Okay, this one ni lah. Kalau ada melibatkan, you boleh tengok balik dalam class 23 nanti, dan 24. Contractor boleh claim kalau there's no disconformity. 6.4, contractor's obligation not relief. After providing all document and testing, contractor obligation still not relief. Of course. Okay, 6.5 ni, we're talking about when the works is not accordance to contract. What is the steps? What is the sequence? What we can do as architect? Of course we instruct. Kalau ada kerja-kerja yang tak ikut kontrak, quality dia tak up to level required. For example lah, you buat lantai marble kan, contoh marble. You expect this hotel lah tu, you expect this floor must high class. So suddenly contractor buat. So ini the option you have. Kalau tak ikut, you buat lantai tak ikut contoh. Architect shall instruct contractor to remove from or not to bring to site. Kalau ada material lah. Let's say material tu sampai, alamak, marble ni tak ikut lah. No, reject contoh. Atau you boleh buang. Demolish and reconstruct. Kalau dah bina, boleh. Demolish and buat baru. Because memang tak ikut spec. Tak ikut expectation you nak. 3. Rectify as instructed by architect. Let's say dia dah pasang, okay lah, kita can accept. Tapi you kena rectify sekali lah. Maybe you kena pecahkan 1-2 ke, atau you kena whatever lah. 4. Contractor may counter propose subject to architect approval. No additional cost. Two option. Or may accept. Just accept whatever contractor did, contractor constructed with employer's consent, subject to set off. Okay, we accept, but whatever bad quality kan, setback of this work, kita akan set off lah. Okay, you setuju? Okay, buat itu. So this is the option. Accept tu mesti redha lah, redha, you terima je lah, you just accept. Okay, 6.6, no compensation in time and cost. Compliance to 6.5, no contractor cannot claim for EOT lah, or LNE, loss and expense. EOT time, LNE, loss and expense money lah, okay, you cannot claim. Kalau betul 6.5 ni due to their default lah, right? 6.7, failure of contractor to comply to AI. Employer may employ and pay other person to carry out recover from contractor. Employer reserve right to determine under 2.5.1. Okay. 6.8, warranties in respect of materials and goods. If required under contract, contractor to procure and submit warranties guarantee. Of course, doesn't relieve contractor of any liabilities. This one self-explanatory lah. You boleh baca lah. You boleh baca. Okay, clause 7 ni, dia talk about royalties, intellectual properties, if any, during construction. Okay, 7.1, sorry, indemnity to employer. Indemnify lah, indemnify, macam you cover lah, macam insurance kan. Deemed to have been included in contract sum. Okay, shall indemnify the employer. Ini dia punya statement lah. Okay, 7.2, contractor's liability to pay. Where in complying to AI, architect instruction, contractor inform architect of infringement in writing, then architect insists in writing. Contractor shall not be liable for it. Okay, any royalties, damages shall be added to contract sum. Okay, if not inform architect, contractor shall be liable at its cost. Kalau ada ni lah, liability to pay, and then you have also government royalties. Except provided in the contract, contractor shall pay all. Kalau ada lah, contohnya royalties. Contohlah, you ada guna tanah ke, you ada guna lot government ke kan. Kalau terlibat lah, kalau terlibat, then contractor will cover the cost lah. Alright, site agent ni kalau bahasa mudahnya ialah project manager lah, mewakili or on behalf of contractor lah. Kalau project kita biasa project manager kan, from contractor side. 8.1, to appoint competent person lah, of course, deemed as contractor authorized site representative as necessary to execute the works efficiently and satisfactorily. If architect not satisfied, may instruct additional without cost. Okay. 8.2, instruction to site agent capable of receiving, of course, ni penting in bahasa, both bahasa English and bahasa Melayu. That person must capable of receiving instruction. Deemed to be authorized by contractor to receive instruction given to site agent, deemed given to contractor. That's why bila you buat site organization chart kan, itu penting. You bertukar orang, kena inform. And you tak boleh lah tiba-tiba suddenly contractor change project manager today Abu, tomorrow change to Mutu. Tentu je tak boleh. Because that person deemed to be authorized. Because this person, when we give any instruction, is as good as we give instruction to contractor. That's why you can update organization chart, kalau ada perubahan, pertukaran dan sebagainya, this person must be, we consultant must be informed. 8.3, exclusion of persons employed on the works. Architect may, but not unreasonably and vexatiously, secara ni instruct dismissal of site agent or any contractor site staff. Upon instruction to immediately remove and replace in time and not re-employed, no AT or loss expense entitled. So architect ada power. If we found out this person, alah, dia ni tak boleh buat kerja lah, or we have some bad feeling lah, you know, architect boleh tak boleh, tapi without unreasonably lah, tak boleh tanpa alasan, tak boleh secara membabi buta kan, ataupun secara kasar, viciously bisa ada reason, kita boleh dismiss that agent. Okay, so contractor bertanggungjawab to change lah. Alright. Access to works, of course, this one is talking about at all time. We have consultant, all parties involved. Contractor must give reasonable access to works and to the site. Sama juga dengan subcons kalau ada. Okay, contractor must provide access. Class 10, site staff. Okay, duty of site staff. Employer may appoint such number of site staff, act as inspector under the architect. Contractor to provide reasonable facilities. Site staff ni, kalau site agent ialah project manager, site staff ni IOW lah, ataupun COW, ataupun resident architect, yang praktik kat luar kan. Tapi kalau based on Architect Act, kita panggil dia IOW lah, Inspector of Work. Okay. Employer may appoint such number of site staff, act as inspector under the architect. Okay. 10.2, directions given by site staff, no effect, tak ada effect, tak ada weight. Any instruction, direction given by staff tak ada weight. Tak ada weight. Unless given in writing, confirmed by architect. That's why dekat site, we will tell COW or IOW or contractor that, okay, kalau IOW bagi instruction, tak ada effect. So, how? So, IOW will tell architect, this is the thing dia. So, kita yang akan keluarkan. Architect or consultant yang akan keluarkan instruction. That's the way it works. Okay, this ni one of the important clause, VO, variation. In practice, kita selalu sebut VO. Actually dalam kontrak tak ada pun kata VO ni. Variation order tak ada. Tak ada variation order, tak ada. Dia ialah variation. Yang ada adalah order the variation. Tu ada. Order the variation, but not variation order, tak ada. So in exam, please use the right word, variation. Variation. There is no single definition of what constitutes a variation. Usually, any standard form of building contract will contain a definition of variation in terms of specific actions and activities. PAM, standard form of contract, in clause 11, define the variation as alteration, blah, 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 blah. Dia ada explain pasal, there's no one lines explanation lah about variation ni. But they have a series of definition and explanation. Okay. Clause 11. Definition of variation in a PAM contract, clause 11. The term variation means the alteration or modification of the design quality or quantity, both quality and quantity of the works, including all those things you baca. The addition, omission, or substitution of any work alteration of the kind of standard of any materials or goods to be used in works, the removal from the site of any work executed or materials or goods brought thereon by the contractor for the purposes of the works other than works, materials or goods which are not in accordance with its contract, any changes to the provision in the contract with regards to changes perubahan termasuklah limitation of working hours. Kalau the project, the working hours say 8 to 5 for example, or to 6, suddenly you pun bagi arahan, contractor please carry out the works with extra time until malam. Remember, tak boleh. Itu adalah variation untuk contractor. Boleh, contractor boleh buat, tapi dia akan claim VO lah. Dia claim extra lah, because you dah change the working hours. That's why, sometimes, I tahu practice, sometimes kita bagi surat. Contractor, please expedite your works. To complete the works earlier, please add working hours, or consider working 24 hours, or blah blah. Tak boleh because you already bagi ruang untuk claim VO. Termasuklah working space, access to relation to any specific part of site, the execution and completion of works, and then execution of temporary works. Ini pun sama, ni baru masuk dalam 2018. The 6 ni tak ada. But shall exclude any changes due to contractor default lah, negligence, omission, default by contractor. So of course kalau ada default by contractor, the contractor dia akan tanggung sendiri lah at its own cost. Cost of variation, yeah, of course, they involve all the parties. Sometimes the variations come from client, normally from client lah. Normally, it can be come from contractor or consultants or others. It may be from authorities, kan? Authorities bagi instruction. You can tambah satu lagi TMB substation, contoh. It's variations, but come from authorities requirement, for example. Of course, the effect, cost overruns, time overruns, you're talking about professional relationship, dispute among professionals, you boleh baca lah, addition payment for contractor, procurement delay, dia akan effect lah. Normally akan effect. Ada variation akan effect dia, kesan-kesan dia. Effect of VO to project parties, consultant, contractor, client, more paperwork, more meeting of course, more arguments kan. Okay. Okay, this one important. You don't want to. No variations required by architect shall vitiate contract. Okay. You tengok pecahan The architect may issue an AI ordering. Ni datang order tu. Ordering, bukannya variation order. Yang kita duk refer order ini dia. AI ordering a variation or sanctioning any variations made by contractor. Maksudnya, any item related to variation, architect dia dua options. Terjadinya variation ni. Two types. Satu ialah order the variation. Satu. Order means arahan lah. You bagi AI. Arahan. Itu type nombor satu variation. Ataupun sanctioning. Sanctioning ni lah you bersetuju lah. Sanction kan. You setuju, you approve. Untuk perubahan tu. Tak semesti dalam arahan. You bersetuju pun yang bentuk persetujuan pun untuk AI juga. Variation juga. Contohnya apa? Contractor submit you something, please confirm the changes, for example. Okay, we setuju. You also consider, tapi must be issued by AI lah. Sebab AI tu wajib. Wajib dalam memastikan that variation tu lah. Kan? From the contractor. Line 2, no variation ordered by the architect or subsequently sanctioned by him shall vitiate the contract. You dah order, you dah setuju, ingat, apa-apa pun you buat, arahan tu, mesti satu within the contract. Dan dia tak boleh menjejaskan contract. So, you tak boleh lah bagi arahan-arahan, macam tadi lah cakap kan, perubahan menambah 2 kereta, Ferrari. Itu menjejaskan contract. Because Ferrari sebiji dah harga berapa juta kan. Kontrak baru juta. Tiba-tiba bagi ada tak ada kaitan kontrak. Atau dia dah menjejas kontrak. Tak boleh lah. That's why architect's power, there's a limitation. There limitation. So that's why architect is important or consultant is important. You must know, you must be very fair. You know your basis. Kan? Any instruction tu tak boleh memandai-mandai. Kan? Jejaskan kontrak ni maksudnya apa? Kalau you rasa arahan tu, that variation tu, menyebabkan contractors at the losing side, kan? Contoh selalu bagilah, saja bagi exaggerate. Selalu bagi for example, you ada projek tu nilai dia 100 juta. Buat satu tower. 2 tower lah for example. 2 tower 100 juta. Suddenly, klien pun bagi tahu klien, architect, could you please give instruction to contractor to do omission, kan? That 2 tower yang projek tu harus 100 juta, omit 1 tower. So simply take 100 million jadi 50 million lah, kan? Because you omit half. Boleh ke tak boleh? You rasa boleh tak boleh? But right, if you understand this clause, this sub clause, tak boleh lah, because you omit separuh. Apa kesan dia? Apa konsekuensi? Projek 100 juta. You punya retention sum is based on 5%, is based on original contract 100 million. You omit separuh, you punya retention sum bila you buat interim set nanti bayaran, you tetap base kepada 100 million, bukan 50 million. Kontraktor dah order barang ataupun order machine, crane, whatever, based on 100 million scope of work. Suddenly you omit. Wow. Kontraktor dah rugi lah. Dia dah bayar ni dah rugi. So itu menjejaskan kontrak. Cannot lah. That's why. Variation, kalau employer want to do, contractor must do based on AI issued by architect, but have some limitation. That's the idea. So, pending the evaluation of the variation, walaupun AI dah given by architect, contractor shall carry out with due diligence and expedition all variations so instructed. Dia kena buat. Itu masih perlu lah. Okay. The short note at the bottom you can read lah. If contractor had carried out the variation work without AI, architect may issue AI to finalize instruction any time before an account. The power to sanction not limited to claim for extra payment only, but includes omission which result in reduction of contract sum. The contractor has an obligation to carry out AI and not wait to agree price of variation, since it will be valued under clause 11.6 and payment under clause 7.9. Okay. 11.3. The architect may issue instruction in writing requiring a variation at any time before the issuance of the CPC. Thereafter, any AI, ingat variation only occur during construction. Start project until CPC. But after that, dah tak valid unless issues related to authority, authority or service provider. This one clear lah. Means AI after CPC. This one, AI related to variation after CPC can be issued. Only any matters related to appropriate authority or service provider. Okay. 11.4. AI on PC sums and provisional sums. 11.4. Architect shall issue AI in regard to the expenditure of PC sums and provisional sums. Okay, this one you boleh baca dekat definition apa itu PC sums, apa itu provisional sums. Okay. Dia akan relate back dengan, kalau PC sum dia akan relate back dengan clause 27, 28. And provisional sum dah, you can read apa itu provisional sum dekat definition. Nampak sama tapi tak serupa. Apa itu provisional sum, apa itu sum. Tapi for both item, architect shall issue AI. AI is compulsory in regard to the expenditure of PC sum and provisional sum. Alright. Okay, this one short notes lah. This clause enable architect to give instruction to formalize PC sum and provisional sum. Works under provisional can be carried out by contractor as VO. Okay. Provisional sum can be converted to PC sum. Boleh convert to PC sum. PC sum ni, okay, any item related to NSC, PC sum, clause 27 and 28. Unless work under PC sum or provisional sum, architect can issue instruction to nominate NSC or NS. NSC is nominated subcontractor, NS is nominated supplier. If again of variation, 11.5. Okay, 11.5 is we're talking about variations and provisional sums. Kalau ada variations, of course contractor akan buat kerja lah. In terms of work, they will do the works. But in terms of valuation of the works, okay, variation shall be measured and valued by QS. Ini kerja QS lah. Upon completion of variation, QS now required to submit complete details and particulars to architect and QS to variation of variation. If you read dalam clause, PEM 2006, right? Clause 11.5 ni dia tak cerita pasal timeline. Dia hanya cerita pasal, okay, kerja variation ni perlu di value oleh QS. That's all. Dia tak bagi timeline. Dalam PEM 2018 dia dah update pasal timeline. 28 hari, 28 hari, 30 hari. Apa tu 20 hari? 20 hari ialah QS akan, if they think that they require more details, they can ask contractor to provide more details dalam masa 24 hari. Masa dia tengok value tu, okay, dalam masa 24 hari, okay, contractor please, I want more detail lah. I require more details for this particular variation work kan. Contoh variation A. So dalam masa 24 hari lagi, 28 tambah lagi 28, contractor will provide maximum lah, within 28 days, provide the extra details. So after that, upon receive, QS have another 30 days to value the variation. That's the timeline. Okay, 11.6. Tadi we talking about contractor to QS to value the variations based on certain timelines. And you're talking about the rules of variation pula. Rules ni you're talking about rates dia, apa kerja dia, keadaan macam mana, ni semua. 11.6 they talk about that. Okay, you have subclause A, B, C, D, E, F. Tapi you focus on A, B, C, D lah. Okay. You akan jumpa kataan similar character conditions. Apa tu character? Apa itu conditions? A, you're talking about for the works ataupun for the variation have similar character under similar conditions. B, similar character, different conditions. C, not of similar character. D, cannot be properly measured. Apa ni? Pening kan? Okay, before that, kita faham dulu. Apa itu character, apa itu condition. To make it short, character ialah kerja. Kalau in this case, for example, you see the photo, the painting work is character. Kerja lah. What is condition? Condition tu adalah cara kerja. And the way you do the character, the works. For example, the character is painting. The condition, you standing. The character is painting also. The condition, using leather. The character is painting also. But the condition, you use crane for example. Kan? Pun boleh. So itu kita faham lah. Apa maksud character versus condition. Okay. Ni. Character paint job, condition is the way you do the job lah. Alright. Okay. This one, the expression lah. Okay. 11.6a. Similar character, similar condition. Of work in contract such as addition to painting work in the building. For example lah. B tadi, similar character, different conditions. Similar work included in the contract, a painting, but don't need scaffolding as working at high level. So you need other way to do. Dalam kontrak kata guna tangga, tapi mungkin you require scaffolding or crane or whatever. Okay. C, not a similar character. New proposed material not included in contract be curate such as painting change to epoxy paint for all external building. Memang langsung tak ada lah ni dalam kontrak. Kan? You tukar material lah. You tukar material tu. D, cannot be properly measured and valued. For example, ratification of pattern defect by third party to rectify default contractor work. Okay. Kalau similar character, to executed under similar condition A, so rate and price as per contract document, straightforward. Because benda tu dah ada lah. The character painting work dah ada dalam kontrak. Cara kerja dah ada dalam kontrak. So senang. Bila ada pertambahan, kan, ataupun ada variations, when QS want to do the valuation, senang. Very simple. Because, so kalau you practice tahu kan, kalau boleh, kalau any variation, perubahan tu based on whatever dah ada dalam kontrak. Tu prinsip standard mana-mana projek kat luar lah. Kalau you practice. Kalau boleh jangan, contoh macam I architect. I want to change from tiles to marble. I akan make sure I change to marble tu ada dalam kontrak. Because saya tak nak pening kepala nanti akan bergaduh pasal isu cost, isu rates kan. That's what easy for A. Rate and price as per contract document. Easy. B, similar character executed under different condition. So of course, you akan tengok kalau benda tu tak ada similar character tapi different condition. Contoh you tadilah chart tadi kan. You buat kerja tu berbeza kan. You akan tengok balik fair adjustment in the rates to take into account such difference. C, not similar character. Cara kerja tu memang langsung tak ada. Material tu ataupun kerja tu langsung tak ada kontrak. Fair market rates and price determined by QS. So QS main role lah, main peranan lah. D, cannot be properly measured and valued. This one, ni kalau tengok dia ada kaitan dengan yang sebut tadi yang awal. Cost plus. Cost plus ni ialah you akan base atau you akan value based pada rates, day work rates in the contract document kalau ada. And then actual cost. Kalau actual cost barang tu, contoh barang ialah so you kira apa? You calculate, satu ialah day work rates, kan? You bayar pekerja. Kedua, barang. The barang itself, the price, the cost of the barang, the materials, plus 15%. Ni ialah cara cost plus sebenarnya. Yang kita sebut cost plus tadi kan, awal tadi. And EF very straightforward. E untuk item yang you omit, kan? You omit barang tu, okey lah, senang. Memang tak ada apa isu. You omit je lah. F is related to provisional quantity. Rate as per the contract document. So, dia pertambahan 60 hari kena buat lah. Alright. Schedule of rates determine omission. Of course lah. Okay, ini self explanatory lah. Okay. Ni another form of flow lah. You can baca variation procedure by client, must inform architect to check with all condition and cost, estimates, variation by architect, report reason of course lah. Kalau you buat report, because macam ada setengah-setengah client, you nak buat variation is not easy, kan? Macam kalau biasa buat dengan PJC ke PJH yang ada PMC, lagi pening kepala nak kena report, nak kena present. It's not that easy. It's not that easy. And then contractors, others, must inform architect. Kalau variation tu proposed by contractor, of course contractor kena highlight dulu dekat architect ataupun consultants, NQS. Kita akan check dulu upon got approval from the client. Okay. Right. Okay. 11.7. Okay. 11.7 they are talking about additional expense caused by variation. Maksudnya apa? Okay, kalau kita 11.5 tadi, 11.5 tu ialah the variation work itself already will increase the cost, betul tak? For example, very simple contoh lah, example lah. Let's say lah, projek tu okay lah. Tu ada contoh kan, 100 meter cube concrete for example. For example, kerja tu require more concrete cube. Let's say original ialah 50 meter cube. So you want to add ada variation 100 meter cube. The 100 meter cube concrete is a variation. Okay. Of course, rate je kita akan base tadi 11.6 rule dia. You akan base pada rate pada yang ada dalam kontrak. Okay. So katalah 100 meter cube tu harga dia contoh yang tahu. Say 100,000 lah contoh. 100,000 cost dia. Contoh. 100,000 tu ialah cost per se of that cube ataupun of the concrete only. And any cost related lah, condition dia, character dia yang involved. That is the cost yang QS akan value. QS akan value dalam 11.5 tadi. But there's a thing that because of this variation, they might have additional expense. Contohnya apa? Contoh dalam bila you buat concrete tadi, kontrak asal betul ada contohnya mungkin dia buat tu pakai tak perlu crane. Sebab projek dah habis, skop kerja dah habis, so crane tu dah tak ada kat site, dia dah dismantle for example. So in order to add that variation 100 meter cube, so kontraktor kena order lagi baru tower crane, kena tempah sewa baru. That additional cost, that's where we relate to this clause 11.7. Tower crane punya cost tu. Cost concrete dah masuk dalam 11.5. But 11.7 we talk about additional expense due to apa-apa yang baru yang berkaitan kerja variation tu. Itu beza dia. So you must differentiate 11.5 and 11.7. 11.5 purely on the cost of the variation itself. 11.7 ialah apart from the cost of the variation, you have additional cost due to variation. Kena bezakan. Okay. So dalam kelas ni akan cerita pasal kontraktor kena submit dalam masa 24 hari, the details, kalau ada intention, and then after kerja dah siap, dia submit lagi detail 24 hari. So ni mungkin tak faham, kita tengok timeline. 11.5, 28 hari, QS inform contractor to submit more details. 28 hari lagi, contractor to submit details. And then QS have 30 days to value for the variation works. Whereas 11.7, submission of additional expenses. Contractor within 48 days to submit notice from the date of AI or any relevant works lah. Dia akan bagi notice dulu, intention dulu. For additional work, I want to submit notice regarding additional expenses, tower crane. Okay, dah masuk 2 hari. Completion of the works, another 28 days maximum. Maximum, contractor akan submit all the details. Tower crane, the cost, blah 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 blah. So remember, so 11.5 plus 11.7 is the cost involved for the variation. Right, clear? Okay, access to contract books and documents. This one is a straightforward explanation lah. Contractor shall keep records to substantiate all these claims, shall submit all particulars to the QS free of charge. Dia must tolong lah. Contractor will help consultant lah. Dia nak kita claim VO atau variation, you help us lah with all the documents. That's the idea lah. The document, the books. Okay, 11.9, variations and additional expense, yang tadi kita pasal cost tu, once dah setuju, dah ascertain the amount, the cost boleh dimasukkan, shall be added to the interim cert, clause 30 nanti. When you pay the contractor, clause 30, okay, you pay through interim cert, progress payment, you boleh masukkan this variation, cost dia. Okay, can we break set 5 minutes, 6 minutes, boleh? Boleh tak? Kita sambung lagi dalam pukul 4.12 ke? Boleh? Kita sambung sekejap lagi. Kita break sekejap.
Hi everyone. While we're having a break, while you're drinking your coffee and while waiting for Architect Fakri to come back, do you mind for me to share this issue a bit? Just for all my engineering friends to be aware of. Okay, currently the Board of Engineers Malaysia is proposing an amendment to Act 138. Okay, so I already shared in the WhatsApp group the proposed amendment. Yeah, the soft copy of the proposed amendment I already put in the WhatsApp group for you to have a look at. And of course, you must read everything first. You must read from the first page until page 23. So some of the amendments, yeah, including the change of the composition of the board within the Board of Engineers Malaysia. And then the registration category. So now they would like to include previously, under the amendment of Act 138 in year 2015, they included the engineering technologist. Okay, they include engineering technologists and the registration of inspector of work, IOW. So now they would like to add on further the people who can be registered under Act 138. Okay, you can see here they would like to add on from H to N. Syarikat penyedia perkhidmatan kejuruteraan. What is this? Professional Engineering Technologist, penolong jurutera, penolong jurutera bertauliah. I have no idea what are these things, even though the explanation is here, but it's still very confusing lah. Penolong jurutera, orang berdaftar sementara. What is this? Juru ukur bangunan, this is a building surveyor, and then the professional building surveyor, because at the moment there is no act that governs the building surveyor. Now they want to park it under Act 138. Okay. There are many types of surveyor. We have the quantity surveyor. They have their own act since 1967, together with architects and engineers. We have 3 acts that has been gazetted together in 1967. And then we have land surveyor, the licensed land surveyor. Licensed land surveyor also, they already have their own act. However, for building surveyor, they have no act that governs them. So now they would like to park under Act 138 as one of the people who can be registered persons under Act 138 lah. Okay. And then you go through on page 10, you can see, okay, for PEPC, now they want to put the prefix IR. I think it has already been IR for forever since 2015. Okay, anyway, dia nak letak suffix PNHPC. What is this? Panjang sangat lah. Aku pula banyak complain. Sorry, I'm not a registered person under Act 138, but I'm just it is related within the construction industry. Sorry, Okay. Now for jurutera, now they want to change the word jurutera siswaza, meaning that the graduate engineer, they want to change it to become engineer. So the new title suffix will be ENG at the back. And then IOW, okay lah, technologies kejuruteraan. Now they want to add in technologies kejuruteraan professional. What is this? Okay, lepas tu tengok dia nak letak title IR. I find it very strange lah. I find it very strange because IR since 1967, since the establishment of the Registration of Engineers Act 1967, it is acceptable not just in Malaysia, even for abroad. They have been using this title IR to indicate people who studied pure engineering, whatever field you are, civil ke, mechanical ke, whatever lah, pure engineering, and has gone through adequate practical experiences to be recognized as a professional. So now if you put IR to professional engineering technologist, how are you going to differentiate what are you actually, what type of experiences that you have gone through previously in your studies and so on, and whether are you able to become a submitting person under Act 133? So for myself, like myself as an architect, I have to ask further the person, are you able to become a submitting person under Act 133? You know, it's a longer process to investigate one IR to another to know what are you actually. Okay, for now we have PE and PEPC. Okay, like myself, I'm aware of Act 138, so I am able to tell, okay, immediately the question I can ask, are you a PE or are you a PEPC? So if you're a PEPC, I know you can become the submitting person. I can merge together with you in a project or whatever for under Act 133. Okay, that is very clear. But when you add on the same title to someone who did not go through the same process as pure engineering people who went through the studies and the educated experiences, it will create confusion, not just for me as an architect lah. I'm talking about the general public. The public definitely will get confused. Who are you actually? Okay, and then dia nak tambah penolong jurutera, and then they can use this title ASST.ENG, and then penolong jurutera bertauliah cert ENG. Okay, so building surveyor pun dia nak introduce a new title BSR. Lepas tu ada suffix pula dekat belakang dia. So, I leave it to the judgment of everyone in this class and everyone who are registered under Act 138. Please read this, and then you can protest or you can give comment and you can improve whatever that you want to on this website. Okay, go to the upc.mpc.gov.my. Actually, the link is also on bm.org.my website. You just click to this link, and then actually any act or any law of Malaysia that they would like to amend, they will ask the public opinion on this page. Okay, for example, like this one, Department of Standard Malaysia, the regulator, and then they tulislah public comment for DMS whatever number. Okay, public comment for whatever. You can give comment. Anyone can. Because this is a public website. Okay, and then you just scroll sampai dekat bawah ni. Nampak ni consultation on proposed amendment to the Registration of Engineers Act 1967, Regulator Board of Engineers Malaysia. So you can give your comment or whatever you want to say about this amendment before 9 of September. So you have 15 days left. Use this time wisely to give whatever input that you want to. I'm not a registered person under Act 138. I'm an architect registered under Act 117. So I'm just telling this. If you have a better idea on, for example, any comment lah that you want to give. You're all intelligent people. Kalau not intelligent, you are not engineers. You are engineers, so you're intelligent people. So you can give your input whatever that you want to. Whether you agree, you don't agree ke. Okay, any further comment on this website, you just click lah. For example, like this one, you click on this, and then you will come into this page. Yeah, dia bagi tahu dekat sini purpose of consultation, affected stakeholder consultation document. This one I already shared in the WhatsApp group. You can also download here. And then you click on submit comment. Whatever that you want to say. Do not wait until after the 9th of September. Lepas tu kalau tak puas hati ke baru nak marah. Why BM is like this? Then you did not use your right within the time given. Please use your rights as a registered person under Act 138 to give your input, comment ke, nak protest ke, agreement ke, disagreement ke, whatever it is. On this page. So BM will get your message lah, what you want actually. Okay. So yang ni document dia I already shared in the WhatsApp group. Okay, so I stop share this one. Make sure please use your rights. Please use your rights as a registered person under Act 138. My worries is that because BM and then Lembaga Arkitek Malaysia and Board of Quantity Surveyors Malaysia, they are all under Kementerian Kerja Raya. We are triplets. Kita ni kembar tiga. I'm afraid that say if this amendment has been approved and then gazetted, later Board of Architect Malaysia will copy BM. Lepas ni siapa pula dapat title AR ni? Because we also have architectural technologies under Act 117, which is the Architects Act. We also have IOW architectural registered under Act 117 as well. The amendment on the same year with Act 138 amendment in year 2015. They amended the act together, gazetted together. Risaulah pula kan. So I hope everyone will do your part. It doesn't matter. It is whether you agree or you do not agree. You just put in your comment there. You are allowed to do so. But please use this 15 days wisely. Read through the document. Think wisely before you put in any comment lah. You can say yes, I agree, or I don't agree. It's up to you. But use your rights. 15 days left. Jangan nanti dah lepas amend baru nak komen. Oh, kenapa? Okay, everyone. Apa tu? Oh, there's a comment. Can attach the attachment here. Sekejap, saya cuba park attachment here while waiting for Architect Fakri to log in lah. Dia PDF lah. Tak boleh attach lah. Can I just provide the link? Dalam WhatsApp group ada, saya letak PDF dekat situ. Because I cannot attach PDF file lah dekat sini. Lah, tak boleh. I cannot attach a PDF file here on the chat box. Okay. Baca the particular document. I copy paste the link here lah. Kejap mana tadi website tu? So use your rights, everyone. UPC mpc.gov.my. Okay, I paste here. So you can just go there and pergi scroll ke bawah, cari yang BEM punya tu. And then you click. Okay? Alright, that's one. That's just for everyone's info. Okay. Sorry to take your break time. Okay, I pass back the class to Fakri.
Okay. Okay, semua still, everyone can listen my voice, Oh, tadi dah hilang I punya slide hilang. Okay. Before that, I think I tengok dulu ada chat question ni. Tengok satu round We try to take around 5 to 10 minutes ke. Okay, ni from Ang Wei Zian. Under PEM, does architect allow to delegate his power to engineer for issue payment certificate for engineering work and assist in the you nak delegate power to engineer for issue payment cert? Tak boleh, tak ada. Dalam PEM contract memang architect je. Tak ada tak ada. You delegate, tak ada. There's no such thing of delegate. Tak ada. Dalam PEM contract tak ada sebut pun. Okay, there's no such thing. Assist, okay. Assist is no problem. Assist, of course, as engineer, we need your assistance. But we're talking about your tanggungjawab, architect, in regards with payment. Okay. Can main contractor charge for project management fee from client for design and build or turnkey contracts? Project management fee for clients for, because okay, ini different procurement you're talking about procurement either design and build or turnkey. You must remember, okay, for example, like design and build, kalau kata project management fee, up to you lah. Because you masuk, you project contoh design build satu procurement, all the costs involved including fees is part of the cost. So up to you, contractor, kalau you nak absorb, you absorb, you can claim, up to you. Turnkey lagi lah, turnkey, all the costs covered by contractors. Contractors is a paymaster. Contractor is a financial provider. It's all by contractors. So you don't, but of course you can include, no problem. You can include all the fees, termasuk fees, project management fee ke, consultant fee ke, of course. But of course, and then end of the day, client might agree lah. Dia tak tengok, they might see lah the cost, is the professional fees, blah blah blah, on paper, right? Is it okay to provide more brand names specified in the tender document? You are talking about specs lah, right? You're talking about specs during preparing tender document. That's why in practice, we normally tak sebut nama ni, we tak sebut. That's why we, and then we were all equivalent because we want to avoid any conflict of interest, but of course, I know outside there's a practice that the client want this certain brand, but we advise that we prefer either use this brand or equivalent, because the idea is what? The idea dalam we consultant, we have given certain specs. We are not the suppliers or certain brand reps or representative. No, we as consultant, we set the quality only, the level, the standards. But contractors still have right to, that's why I said counter propose all those. Okay, we set the standards. What is the minimum standard? For example, CRIMS, warranty, the quality brochure, all those we need that. That's why kita tak bagilah dalam ni untuk bagi nama. For specialist project like nuclear plant, is open or closed tender more preferable? It's all up to the client lah. I cannot advise this. When you talk about nuclear plant, is it's most likely project-project yang sulit kan, sulit. Mungkin you select close, of course lah. But you might advise your client lah, close or selected. You know? This is all client preference. You nak buat dia selected ke, you nak buat dia open ke, you nak buat dia apa cara sekalipun. Of course you can advise lah. Because nuclear plant might involve a security matters, right? In a situation where a client will do the tendering and procurement, if client decide to use their own contract, any implication? Can employer use their own contract for costing? Of course lah. If your client is JKR, then they want you to use JKR form. Up to them. That's why I said today's session, we learn about PEM contract. PEM contract. There's other form of contract. Even I myself also got few project that the contract prepared by client, Samdabi, all those things, the big gun, they have their own contract. Okay, asking your question, client decide to use their own contract, up to them lah. But you as a contract, you can advise. Sir, I think PEM contract is the best form of contract because of this. But if they want to change or they want to use other form of contract, up to them. You can advise. Please don't omit this class because of this. You advise. We as architect or as consultants, we do our best to advise them. This is the consequences. Can employer use their own contract for construction work? Up to them. Again, up to them. Sebab dia apa paymaster. Dia tak ada right or wrong tau. Kalau dia nak guna kontrak, ingatlah, akhirnya apa? Akhirnya is agreement between two parties. The employer and the contractors. If contractor agree with that conditions, too bad lah. Okay. Only project that involve architect, then only we can use PEM form of contract. Well, in the case of PEM contract, yes, because the number that you look back at the articles argument, who is the consultant? Architect, engineers, and the it's all architect. Of course, to answer your question straight away, when there is this discrepancy between drawing and spec what BQ which to take precedent. Does a clause of tadi ada sebut pasal hierarchy. If there's a between drawings, look back at the tender documents, the document inside the tender documents, contract document, sorry, that LOA lah, blah blah. Drawings is above BQ. So drawing take precedent lah. If a building has no facade in the contract drawing, okay, but then later on client ni from siapa? Chia Ben. If a building has no facade in the contract drawing, but then later on client would like to have a steel facade on it, can architect issue AI with revised drawing to instruct? Can or cannot? Can lah. It's a variation. But of course, due to this variation, as long as agreed by the employer or the client lah, in the case of architect, we call it client lah. Boleh lah. But you need to pay the contractor lah for any additional works. Any additional cost. Can lah, right? In contract, does exercise renewable skill and care applies to consultant only, conventional contract, whereas fit for purpose apply to contractor. BND is what? Bid and design. Is it what you mean? BND. As the fit for purpose is more critical wording. Actually, okay, you're talking about wording lah. Reasonable skill and care. Actually, reasonable skill ni bukan saja consultant. Every parties that give service, that give termasuk contractor in construction, inclusive contractor, because contractor also have skills and care, reasonable skill and care to be applied, especially involve anything they do lah on site, aesthetic design, for example, fit for purpose. Of course, normally is applied for contractor normally because they are doing any works to be fit with that purpose, with intended purpose. And whatever they do, whatever they construct, they carry out, that works must fit with the original purpose or intended purpose for that particular works. Of course lah. If the work done is not compliance with the standard as per contract, is the work claimable in the next interim claim? Not compliant. Ni tengok you look back at the clause 6 tadi ya. Look at the clause 6. Semua jawapan ada kat situ. Your question ni is already inside the clause 6. First, work done is not compliance or not accordance to contract, right? Is the work claimable in the next interim claim? Claim or not? Kalaulah if the work is you accept redha, then you might set off. If the works you instruct contractor to rectify, then you accept, pay lah. Whether to pay next interim ke, now ke, lagi 2 kali interim is non-related, because remember, work interim cert is work done. As long as work done, you accept, you agree, then you pay lah. Tak kisahlah next interim ke, now ke, next 2 months ke, as long as work done. And Weizian, if such inspection was held after working hour, can architect claim OT for IOW from contractor? Ni administrative matter lah, estimator. Administrative matter. First kali you must know the appointment of IOW, siapa yang bayar, siapa yang appoint, kan? Who appoint the IOW? Normally either client or architect. Both can lah, not contractor. So dia sama macam you lah. You architect, you buat inspection. Suddenly inspection you, let's say you are architect or engineer, you kerja dengan your boss. You buat inspection after office hour. Okay? So you inspection tu you claim dengan siapa? To which party you claim? You claim you're to boss, right? You claim to your boss, not to contractor. But up to the boss to see how. You decide lah. I can claim whether I can claim to contractor. But right, no lah. Kan? The extra works. But if you ask me, you can talk to contractor lah. Ingat ni, you're talking not, your question is related to administrative matters. It's not contract matters. It's administrative matters. You're talking about appointment. You're talking about working hours of the IOW. Okay. Can older version of form of contract be used? Can. No problem. No problem. Now, they are still using PEM 26. They are still using PEM 26. There's more, still a lot of clients still using PEM 26. But of course lah, when as a PEM when they draft any version of PEM contract, they expect that form of contract, the latest one is the updated one. Means they assume that contract is a better version compared to previous one lah, right? Can consultants bid for job online bidding? I know there are online bidding for tenders. Ni soalan online. Apa ni? Saya nak jawab ni. Dia tak ada kaitan kontrak. Ini semua again administrative matters. When client offer any job tenders, tak ada masalah pun. Dia nak buka dekat surat khabar ke, tak ada masalah. Tak ada masalah. Barat tak ada masalah. It's administrative matters. Anything that will stop it, either that bidding process is there's any infringement ataupun pelanggaran law ke kan, ataupun if there's any, then only I can say that you cannot join this online bidding. As long as that online bidding still based on law, no problem. Coffee break. Can attach the attachment ni. Okay. Ni soal apa ni? Okay, PNC. Okay. Previously untuk lagi. Okay. Ni apa ni? This is the discussion with IMED before. Okay. Can architect delegate the engineer to issue EI, meaning that no AI required to cover all the AI? In the first place, EI issued by engineer. There's no such thing of delegate engineer to issue EI. EI from engineer. Remember, at the list stage tadi, I beritahu, in contract, there's no word engineer instruction pun. Ada architect instruction. You can ask engineer to issue EI to cover that scope. And then you later you can cover with your AI. Based on engineer's instruction, blah, 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 contractor, please do it based on this AI. That's it. That's normal what we did lah. AI still required. AI still required to cover that engineer's scope of work. Right? Forget this. It's going to be answering the question in the chat box. Okay, ni daripada Faizal. Yang biasa digunakan dalam bidang conventional and design build. Saya masih baru dalam form of contract. Selain daripada JKR, PEM tadi, ada jenis kontrak lain yang biasa digunakan. Ni you bagi tahu ke you tanya ni? Faizal. Ada jenis kontrak lain yang biasa digunakan dalam conventional dan design build. Okay, again I cakap you, conventional we have PEM, normally lah, conventional, PEM, we have JKR, and FIDIC pun conventional, international. Cumanya drafted by different person lah. Design and build, normally, kat Malaysia ni kita biasa guna DJKR punya, 203A tu kan. Biasanya. Ataupun they from there, they draft their own. Can IOW certify payment or endorse any changes to contract drawing at site? Certify payment, no, cannot. Again, tadi you baca balik. Tadi, clause 10 tadi. Clause 10 said that IOW tak ada apa-apa kuasa pun kat site. Dia hanya boleh, dia membantu. Dia sebagai mata-mata on site. Tapi dia tak ada weight, dia tak ada kuasa. Payment ke, even technical pun tak ada. Any instruction from him will covered by architect instruction. Let's say lah, you okay lah, you tak sempat kan. IOW, please can you provide lah sikit details, cash ke apa. I dah discuss you itu kan. Okay, we discuss and then please you provide sikit. Okay, you pun tengok. Okay, IOW buat dia. Okay, I setuju. Then you cover with AI. Even though the information come from IOW, but since you cover with AI, no problem. That's important. AI is important. Without AI, that sketch ke, that detail ke, that payment ke tak valid langsung at all. But with your AI, since you already agreed, you dah tengok, you baca, you study, you agreed, then only they valid. Apa-apa pun AI, AI will cover. Sama lah AI ke apa sama. AI tak valid AI tak valid. But with AI, dia akan jadi valid. Okay, I shall continue with slide. Kita dah 4.5 Okay, kita cuba laju sikit. Wait, I share balik. Apa tadi? Hilang lah. Wait Lost. Okay, everyone can see Okay, we continue with clause 12. Contract bills. Okay, clause 12 ni lebih kepada self-externary lah. Sama juga dengan clause 13. Dia self-externary. 12.1, measurement of building works. Okay, when you talk about measurement, anything that okay, quality and quantity contract sum shall be deemed to be what as per contract bills. So apa-apa you're talking about quality and quantity as per contract bills. Whatever dalam state contract bill lah. Correction of error or omissions. The contract is lump sum contract. Okay, tadi I sebut I highlighted earlier that our contract is really a contract. It's a lump sum contract. Errors didn't reshape contract but shall be corrected by architect. Ni semua statement je lah. It's a self-explanatory, it's a statement. Okay. 13, contract sum. Contract sum not be adjusted or altered. Okay, ni simple. When you awarded the contract, the amount of contract, say 50 million to contractor. LOA 50 million, blah, blah, blah kan. That contract sum cannot be adjusted. Cannot be altered. Kalau 50 lah. Okay. Itulah total dia. So I said it's a fixed lump sum. 50 million, okay, contractor, you please do the works based on 50 million to do this building based on the drawings, on all the contract documents. Whatever drawings ke, BQ, okay, blah, blah. So fix lump sum. Otherwise done in accordance to the express commission, any arithmetic, unless ada kesilapan arithmetic or computation error in price and rate shall be corrected. Boleh lah. Contohnya, total still 50 million, but dalam dokumen tu, you salah tulis 13,000, you tulis 130,000. But that amount supposed to be 13,000, for example. So you can correct lah. 130,000 you tukar jadi 113,000. Itu tak ada masalah. Because it's a computation matters, computation error or arithmetic error. But doesn't change the ultimate price atau ultimate contract sum tadi, 50 million. And also rationalize. Rationalize ni lah pun boleh buat. QS should aware on this lah. And you know that in practice we did a rationalization of rates. This is the exercise kan. This is one of thing that you cannot change the final sum, contract sum, but you can rationalize the rates. Okay, for example, kontraktor ni kadang-kadang dia masuk harga ada few reasons when they price in. Dia tender tu kan. Satu sebab dia nak cepat. Dia tak sempat nak isi because you tahulah sometimes based on your spec tu to provide to prepare lantai semuanya Johnson Swiss contoh. Alamak, I tak familiar lah with Johnson Swiss. Tak apalah, masuklah harga, I masuk harga ikut narrow granite lah. I don't care lah. I tak sempat nak call supplier, tak sempat contoh lah. Aku masuk ikut harga narrow granite. Contoh, tinggi sikit kan, contoh. And then, tu satu reason. Dia main belasah aja kan, the price. Another reason ialah sometimes dia buat front loading. Front loading ni the contractors common strategy lah. And front loading ni ialah whereby they put all the higher rates at the front part of the contract. Contohnya apa? Structural lah biasanya. Structural, infra, they put the right high rates. Contohnya, yalah, very high rates. But at the back for architecture, contoh, or landscaping, is very low rates. Dia rugi pun sebenarnya. The idea is what? The idea dia nak claim cepat. Dia nak dapat profit cepat. That's common practice by contractor lah when they price in. That's normal two main reason lah when they price into. So client or employer have right to, with the assistance of consultant, to do a rationalization of rates. We rationalize back. We have exercise, meeting ke apa. Contractor, please, can you, I think your price untuk besi ni tinggi sangat ni. You boleh rendah ni. Okay. Then you pun balik kat belakang. So you transfer back, you backload. Instead of you front, you backload. You punya narrow granite ni tinggi sangat ni. Rendah sikit kot. Atau tinggi sikit kot, whatever lah. Tapi whatever changes of the rates you buat, you cannot change the total 50 million tadi, for example. That's the idea. You tukar apa pun, tapi the rates tu can be changed. Can be changed. To tailor suit with whatever discussion you buat lah with QS, with consultants, right? Can be done. Okay, that's what we call rationalization of rates. Okay, tadi we already go to this one. We can skip lah. Difference between with and without quantities. Okay, material and goods. Clause 14. Clause 14 dia highlights on the materials and good per se of the project. Clause 6, you can differentiate. Clause 6, they're talking about quality of the materials, quality of goods. Whereas this clause, they're talking about the physicality of the materials and goods, the ownership, the physical, the status dia of the material and goods. Okay, materials and goods. Materials tu apa? Why materials and goods? Normally materials and goods ialah materials normally related to material that yet to be processed or final process. Goods sometimes dah process. Kalau paling nyata, the simple one like for example kayu lah, kayu. Timber is materials. Goods maybe the door, for example, because still timber kan, but it's already become goods because they dah process. That's why that's the difference lah. 14.1, materials and good not to be removed. Not to be removed means they akan relate back to 40.2. Means if the materials come to site, okay, come to site, once the employer pay the contractor, you refer back appendix, materials on site. Once arrive on site, employer can pay contractor full at 100% of the price of the materials. Then after pay, that materials already become the hak milik employer. It become property of the employer. That's the idea. And it cannot be removed. Okay, once dah bayar, cannot be removed. That's the idea for 41 and 42, right? Then dia will tie back with class 30 lah. Class 30 and you refer appendix. They relate to material on site. Okay, alright, 100%. Employer can pay contractor 100%. Okay, 14.3 talking about responsibility for materials and goods. Contractor shall be responsible, including materials supplied by NSCNS. Okay, warranty of title of goods and materials. When we're talking about titles, means we talk about the pemilikan, the ownership of the goods and materials. Okay, this one will relate back with Sales of Goods Act 2017. I give you an example. Let's say when you order tadi kayu, for example, you contractor A ordered the material supplier from supplier, let's say Ameng. Okay, Ameng is a supplier of the timber. Ameng pun supply sampai dekat site. So employer, I will pay the contractor 100% because the timber already arrived on site. Okay, become the property of the employer already. But you must remember there's still title issue ataupun ownership issue of the timber between contractor and Ameng. Let's say Ameng dia hantar kat site, tapi actually contractor masih lagi hutang. Hutang lagi, debt with Ameng. Contractor A cakap, Ameng, I will pay your timber next month. Masuk buku 55, for example lah. But time pass by, blah blah blah. Contractor dah setahun tak bayar Ameng. Ameng pun tak puas hati. Contractor, why you masih hutang I tak bayar? You have to pay. Then under Sales of Goods Act, Ameng is the title of the timber still lagi under Ameng, not under contractor, not under employer. Under this act, retention of title tu, because contractor masih lagi hutang Ameng. That's the idea. So let's say lah Ameng claim lah, dia gaduh-gaduh, dia claim whatever, then any cost involved, employer boleh claim from contractor because contractor dah buat pasal lah, right? Dia dah buat problem, I dah bayar you full under contract, but you ada problem dengan Ameng under Sales of Goods Act. You hutang tak bayar, for example. Okay, so employer should any loss suffered by employer, employer can claim and set off on the clause 30.4. Right, simple lah. Okay, in 15, 16, they're talking about CPC, practical completion and defect liability. Okay, very important. Practical completion. We call it practical completion. We tak kata definite completion. We tak kata completion. Kita practical completion because it's related to practice. As long as you can be used. That's the whole idea. The whole idea ialah kita buat bangunan. Kita bukan kilang yang buat produk. So we can expect some defects, some uncompleted works. Okay, that's the idea. That's why they call it practical completion. Works are practically completed when, okay, A, 51.A, the opinion of the architect, the employer can have full use of the works for the intended purposes. Boleh guna lah. They can use, okay, with the intended purposes. Kalau you buat kantin tu boleh operate as kantin. Tak boleh menghalang lah. Okay, that's the basic idea. Notwithstanding that there may be works and defects of a minor nature still to be executed, and the contractor has given to the architect a written undertaking to make good and complete such work and defect within a reasonable time. So you still can accept the completion works, walaupun ada kerja, there is a work, a defect with minor nature, you still can assume that still considered completed. And B, other requirements expressly stated have been complied with. Contohnya, employer buat syarat. CPC must come with CCC. Contoh, example. Kalau CCC tak ada, then CPC tak ada issue lah. Contoh. So, employer can add lah, whatever lah requirement they want as part of CPC requirement. Okay. Macam tadi saya kata, SBIT memang dah ada dalam kontrak sebut. So, without SBIT drawings, CPC cannot be issued. Itu memang clearly stated lah inside the contract. Okay, CPC. So when completed, architect will issue cert by architect, not by others, by architect. Certificate of practical completion. When the whole of the works are practically completed, the contractor shall give written notice to that effect to the architect, who shall within 14 days, 2 minggu. A, if the architect is definite that the works are not completed, kalau tak siap, simple lah, tak siap, okay, I tak issue CPC. Cumanya you have to notify NSC to specify any incomplete works or the condition which have not been met. Simple. 50.2B, dia ada 2 condition. Satu ialah you pergi site within 14 days, you pun get notice from collector within 14 days. Okay, siap. Simple. CPC. Another condition ialah so means okay, B1 ialah you pergi site within 14 days. Let's say today you got notice, you pergi hari ke-7, you pergi, okay, the building completed. Then you issue CPC on the date of the notice. The date is the date of notice, notice from contractor. But let's say you give, you go to site on the 7th day, the building's completed, but with few works and defect with minor nature. So you will tell contractor will give you undertaking letter. Architect, I will complete the works, blah, blah, blah. So let's say next time you datang to site, okay, contractor already complete the works and the defect with minor nature. So the date of CPC is on the date of the undertaking letter. Itu je, ya. So to make it lebih clear, you tengok ni, ini paling simple lah. Deadline. Issuance of CPC within 14 days, 3 options by architect. Tak siap, not issue CPC. Simple. So reason, you akan CC pada NSC. 2, issue CPC, the date as per notice. Clear. Ni very simple lah. 3 yang tadi. You issue CPC after receive undertaking. Undertaking related to works or defect in nature that contractor to complete. Date as per undertaking letter. This one is very simple. Okay. 50.3. In the event that contractor fail to comply with undertaking tadi, point 3 tadi. In the event they fail to comply, the employer may, without prejudice to any other rights and remedies which you may possess under contract, you give extra time, or you employ and pay other person, which is tied back with set off, or you just accept. Okay lah, accept. But any setback, any defective works, you akan set off on the contractor. Okay. Okay, of course, relevant of CPC. When you issue CPC, dia akan trigger. It should become trigger point. For contractors, certificate of practical completion obtained, CPC obtained, no longer liable for LD. If there's LD, half of attention becomes due, 2.5%. Defect, DLP period commence. If 12 months lah. Insurance risk end and insurance maintenance period commence. For employers, period for finalization and agreement of final account starts. Possession of site and then over back by contractor. Application start should CC have been obtained. Okay, DLP, defect liability period. Defect liability is a period of time after the construction project has been completed, during which a contractor has the right to return to the site to remedy defects. So this is the only time where after project CPC issued, you contractor already surrender the site to the employer. Okay, they are no more possess the site. So they already surrender the site to the employer. But the LP period is the only time, it's an excuse lah for the contractor to come to site to do any repair works, to do any remedy works. In the appendix, if non-stated, otherwise stated is 12 months, or it can be 24 months, depend on the project lah, okay. Schedule of defects, okay, 50.4. Defect in the works which appear within defects. Okay, to make it short, after the LPN, within 14 days, you look at the timeline below. After the LPN, let's say 12 months, within 14 days, architect will issue schedule of defects. This is what we call latent defect. There are two types of defect. Pattern defect, latent defect. Pattern defect is defect that you see, memang you nampak jadi di depan mata je lah. Latent defect is occurred due to time. From time to time, only they appear. Painting punya issue ke whatever lah, because of time. So when we talk about schedule of defect under 50.4, we are talking about latent defect, because of this occurred after 12 months of time, kan? So after 14 days, architect issue SOD, schedule of defects, contractor to make good the defect within 28 days or longer time agreed, depend on project lah. Okay. So let's say the defect be rectified. So the architect to issue CFGD within 14 days. Okay. If contractor fail to rectify, employer may without prejudice to any other blah 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 employ third party and the cost to be set off. Okay, this one related to CFGD lah, CFGD. Okay. Sorry, this one CFGD. Okay. Okay. Defect ni actually if you look back, there's 3 times saja yang disebut dalam kontrak. Satu, 15 point CPC 50.2. 50.1, 50.2. Defect with minor nature. There is a list of defect number 1, whereby you already tackle during the issuance of CPC. Number 2, 15.4 tadi, schedule of defects. After 12 months, for example, architect will issue schedule of defects. And number 3, 15.5. We are talking about critical defects, which can occur along that 12 months. It can be appear or occur at the month 2, month 4, month 8, depend lah. It's critical defects. So that's why in practice actually, kalau yang you biasa practice yang every month nak buat inspection tu sebenarnya tak betul. Other than critical defects, which is you need to clarify lah what is meaning by critical defects. Actually, defects only to be entertained by contractor after 12 months or after the LPN. That's the thing. Because the conceptual dia, the idealnya ialah the defects that occur during construction, we already pick up during CPC. Number 1. So assume that as good as after CPC, there's no more defect lah. Tak ada defect lah, by right lah. Unless except critical defect. Critical defect ni, kalau you can relate with, for example, defect list by the buyer under HDA. That one you can assume as critical defect. Because what? Under HDA, at any time, after buyer got VP, you ingat you belajar HDA last time. After VP, dia boleh buat list of defect kan? Dia bagi to the developer. So that list of defect tu, the same list of defect developer akan bagi pada contractor. If you based on this clause, by right contractor tak payah rectify pun, because they only rectify after 12 months. Kalau projek 12 months lah, DLP. But if you stated in your contract that list of defect from buyer is considered critical defects, then this clause can be applied. Faham? That's important. Ustaz, kalau you nak buat inspection every month, for example, you kena utilize this clause lah. You kena anggap critical defects. Then only the clause apply. Ataupun the defect can be done lah. Okay. Okay, 16. Okay, 16 ni partial possession. Kalau clause 15, we talk about CPC, practical completion for the whole buildings. Partial, you're talking about the part of the buildings. It's a pre-occupied, means Let's say project tu ada 3 blok. Like employer decide I want to occupy the first block since the first block already completed. Can be done. It's a ad hoc. Ad hoc means decision may be been done along the construction period. So 60.1 possession of occupied but with consent of the contractor lah. If before practical completion of the works overall, employer with the consent of the contractor take possession of any part referred as occupied part. For example, block A tadi kan, 3 block A. The following shall apply. Within 14 days, employer take possession, issue cert. So what does that mean? Anything that relate up after CPC, tadi kita katakan, after CPC will trigger what? Will trigger cert, will trigger LD kalau ada, will trigger DLP. That will apply accordingly to that parts. Kan? Faham lah? Let's say DLP. DLP period will apply, kalau 12 month, apply only for that parts. Since another 2 block belum siap lagi. That's the concept. Okay. So kalau melibatkan LD akan reduce by ratio 1/3. Ya, 1/3 sebab 1/3 ni dah siap. LD yang balance akan apply only for the balance remaining. That's the concept lah. 6.2 possession of occupied part without consent. Without consent lah, without contractors punya agreement lah. Employer may enter and occupy without consent provided completion have been delayed. There's ada 3 condition. Delayed, CNC have been issued, and such entry will not cause any unreasonable disturbance to the project. Can occupy without consent. 6.1 is with consent. 6.2 is without consent. 6.3 contractor to remove equipment, of course lah, to remove his facilities lah. Once occupied for that part. Okay. Jadi repeat balik lah. Partial possession with and without consent is another flow. Can refer. Okay. Term contract 17. 17 is 3 subclass there. Point 1 and point 2 is related to assignment by employer and assignment by contractor, vice versa. Other than his financial institution, employer shall not, without consent of contractor, assign his right, interest, and benefit. You remember, the idea is what? The idea is the contract is between 2 parties. Between 2 parties. Okay? Employer and contractor. Tak ada orang lain. There's no other parties. So means both parties, 7.1 and 7.2, you can assign to other parties. You tak boleh pajak, you tak boleh cagar, you tak boleh. Cannot. You tak boleh. Because agreement is both antara dua ni. Other than his financial institution. Financial institution means whatever financial institution yang give money lah. Kalau for example, in the case of employer, they might buat pinjaman for example. Dengan pinjaman dengan other bank sebab nak bayar kontraktor. Okay. Other than that, dia tak boleh assign. Sama juga dengan kontraktor. Kontraktor dia nak buat projek tu, dia might have financial facilities, say with MARA ke, dengan bank rakyat ke whatever. Other than that, dia tak boleh assign. Because only for that project, bank itu je yang terlibat. Dia tak boleh pergi along, tak boleh lah. Okay. 7.3 lah. There's no Alibaba lah. You tak boleh total sub. Let's say contractor A, they got award with that project. They cannot total sub kepada other contractor. Itu dah menyalahi undang. Ini boleh determine under clause 25, contractor can be determined, ditamatkan employment, breach the contract. Okay, insurance. 18, 19, 20 is all about insurance. I make it short because it's a long clause. You can read by your own, actually. But the idea is 18, 19, 20 is talking about insurance coverage. Clause 18, if you read, they're talking about the keperluan, the necessity to have insurance. Satu, to cover person, and then to cover buildings, which is refer back to 18 is describe contractor liability to have insurance lah. 19, they explains on the coverage to workman, person lah. 20, on the contractor all risk insurance, mostly buildings, buildings. 19%, 20 buildings. Okay, simple lah. The rest you can work lah. You can read. 19 Workmen Compensation Act involved, coverage, SOCSO, all those things. 20 you have contractor all risk, and the coverage natural disaster lah, all those things. Okay, I think I skip a little bit on this because it's just the thing that you have to read lah. Okay. Contractor or risk in the class 20 insurance or risk building. There's 3 types. 20A, insurance of new buildings works by the contractor. 20B, new building works by the employer. 20C, existing building or extension by the employer. Normally kita ambil yang A lah biasanya kan, contractor yang ni. Okay, pukul 5 dah. Kita try laju sikit. This is the timeline lah. The coverage, remember, kalau ada EOT ke apa, make sure they extended. Extended 3 months after the LP. Itu dia punya konsep dia. Okay, 21, date of commencement, 1. Dia akan tie back dengan contractors punya disiplin kerja lah. Contractor to begin works regularly and diligently. Dia akan tie back to contractor obligation, clause 1. To complete on or before date of completion. Okay, if delayed by employee in giving subposition, ini tie back dengan clause 23, EOT. Architect shall grant EOT provided not exceed period of delay. Period of delay dalam appendix ada 3 months. Refer back appendix, period of delay. Any project, there's a buffer for that project to be delayed. 3 months maximum. Okay. 21.2 sectional commencement date. Okay. Sectional 21.2 and 23 ada sedikit persamaan dengan partial possession, clause 16 tadi. But the difference is partial possession is ad hoc. Ad hoc decision by employer to occupy that part. Whereas 21.2.13 ialah employer want to take that part, occupy that part, pre-plan. Dah pre-plan, memang dah ada kontrak lah. You boleh tengok dekat appendix, dia ada sebut section completion. For example apa? For example, kalau you buat housing, you buat show unit. It can be part of sectional completion. Because you want that section, that part to be completed, let's say, within 6 months. Project housing ni 2 tahun ni, 3 tahun ni. For example, 3 years, right? 3 years. But that show unit must be completed 6 months. So that show unit, you can use this clause. Sectional completion. Okay. So dah ada kat appendix. So sama jugalah konsep ni sama dengan partial possession. That show unit for example, once occupied, dia punya CPC, DLP akan apply accordingly for that part only. Okay. Okay, 21.4, postponement of suspension of the works. Architect may issue instruction for postponement or suspension of all or part of the work, but shall not exceed period of delay tadi 3 months. To ensure insurance coverage, okay, ni related to insurance. Dia akan kena cover lah. Kalau delay, as long as dia akan extend lah 3 months after the LP. 22, we're talking about LD. From 98, they would use LAD, liquidated acceptance damages, but now they change to LD only. CNC. If contractor fail to complete by the date of completion or any extra date, architect shall issue CNC. Tak siap je on the date yang sepatutnya, CNC must be issued. Okay. Contractor shall pay employer sum calculated as rate stated as LD. Ganti rugi lah, ganti rugi. From the completion date to the date of practical completion, employer may deduct the sum as a debt from any monies to. Okay. Remember, LD ni adalah satu amount yang ada kat belakang juga, appendix tu. Sehari berapa? Let's say contractor delay. Sepatutnya hari ni siap. Suddenly completed keep delay. One day, there must be amount. Let's say, one day, 1K for example. 1,000 per day. So let's say lah, kalau contractor delay 10 hari, 10 kali 1 lah. 10,000 lah, contoh. Yeah? But remember, LD tak akan appear dalam you punya LD set of apa ni? Tak akan appear dalam you punya interim cert lah. Ingat, interim cert nanti kita akan belajar next week, class 30. Interim cert hanya appear for the work done only. LD tak masuk. Set off tak masuk. Interest tak masuk dalam interim cert. Okay. Interim cert only meant for payment of the work done. 30% work done, 30% lah you bayar. That's the idea. Utang-utang lain tak masuk dalam ini. It's a belakang. It's another deal between employer and contractor. 22.2, agreed LD amount. It's a genuine pre-estimate. Biasanya dah ada lah. Dalam kontrak dah ada sebut lah sehari berapa-berapa dalam appendix. Agreed, the contractor will pay employer the amount without employer need to prove unless contractor prove otherwise lah. 22.3, CNC revoke. by subsequent set of EOT. So once CNC issued, but suddenly you approve EOT, then that CNC akan revoke lah, automatic. Okay, this one is related on how you get the amount of LD. Typically, LD is you're talking about loss lah. Employer must consider the following likely damages or loss, which result from delay: direct cost incurred under contract, loss of revenue and profit, additional project missing cost, blah blah blah. Or it can be based on formula as follow lah. Prime rates set by bank, whatever bank, bank perdagangan, contoh Maybank ke apa, you divide it to 365 days of 1 year and you times contract value. Then you get amount, normally lah, the amount of the LD amount. Okay, 23, EOT. Okay, when you read clause EOT, 23 and 24. 23, you're talking about extension of time given to contractor. So you're talking about time. Whereas clause 24, you're talking about money that you can give to contractor, and due to delay lah, delay. What is the idea? The idea is, kalau project tu delay, tadi project, let's say today is completion date, contractor delay. Two option, either you impose LD tadi clause 22, or if the delay is not because of contractor's default, is other parties default, yang akan kita tengok lagi, then LD tu tak akan terpakai, but you replace with EOT lah. You give time extension. Contoh tadi 10 hari delay, kalau memang salah kontraktor, then you akan impose LD. 10,000 lah bayar, kan contoh. But because of you approve EOT, that 10 hari, you bagi free lah kontraktor, no LD impose. So you extend the completion date from day 1 tadi to the day 10. So the new completion date already appear lah. That's the idea. So clause 23, you're talking about give time to contractor, days and time. 24, you bagi duit, money. You must read side by side. This both clause. 20.1, submission of notice and particulars for EOT. Contractor may apply for EOT provided that 20.1A, contractor give written notice of his intention. Dia bagi notice dulu. With initial estimate of EOT supported by particulars, even within 28 days from EI, CI, or delivery event. And another within 28 days, dia akan bagi lebih details. Bagi details. Okay, final claim of the EOT. Kita akan jumpa relevant event. Relevant event ialah any events that make the contractor to delay the work lah. Later kita akan tengok list of relevant events. 23.2, delay by NSC. Where 23.1 occurred, notice refer to NSC to make copy to NSC. This one just acknowledgement of NSC lah. Okay. 23.3, insufficient info. If not sufficient, architect to inform contractor within 28 days from receipt of contract info, and contractor have to further 28 days to resubmit requested info. Okay. Right. Nanti kita tengok dia timeline. Okay. 23.4, cert of EOT. You nak bagi EOT, you also must have cert by architect. Remember, architect akan provide cert. In order architect to issue the cert, architect must consider the EOT assessment based on 3 clauses, 23.5, 23.6, and 23.8. And as per that 3 clauses, shall either reject with reason or issue cert of EOT within 6 weeks. It may be before or after completion date. Okay, what is 23.5? 23.5 is other consideration for EOT. Ini adalah role of architect. Architect may take into account effects or extent of any works omitted under contract, provided that not fit the completion date earlier than stated in the appendix, or any other relevant events that may have effect on contractor entitlement to EOT. We can consider any other relevant event if we think that give effect to the contractor works. So if 23.5 is architect's role, 23.6 is contractor's role. Contractor still have role to prevent the delay. Use his best endeavor to prevent delay. However, cost have to be to the architect. Macam ni dah tak ada. Kalau PEM 2006 have to be to architect selection, but now no need anymore. 23.7 notification to NSC, share notify NSC sama to notify NSC when we fix the letter of function date, letter another date lah function date. We must notify NSC. It's important. 23.8 relevant events. Events there's two types: beyond control, which is act of God, blah blah blah, or within control. It might be from employer or consultants. Okay. 23.9 EOT after issuance of CNC. Architect may grant EOT if relevant events occur after CNC. Boleh, tak ada masalah. Even though after CNC and the relevant events occur, still can give EOT. 23.10 Architect's review of EOT after practical commission. Architect may review within 12 weeks after CPC. Boleh juga. Ini semua body bicara architect ada kuasa. Review shall not result in decrease of previously granted EOT. This is a list of relevant events. Banyak if you can read force majeure. Apa maksud force majeure? You refer back definition article 7. There's a explanation. COVID pun force majeure. Ada pengontek COVID force majeure. Exceptionally inclement weather means cuaca yang amat teruk. Yang tak sangka. Bukan yang sangka tau. Kalau hujan you dah sangka dah. Tak boleh. Tapi let's say hujan tu pelampau lebat di kawasan tu. Then can be considered. Damages resulting to insurance claim relevant to clause 20. Ni apa-apa yang damage related to 20 ABC boleh claim. Banyaklah, the rest you can read. Okay. Even termasuk dengan clause 21 tadi, delay by employer in giving subordination. This is the clause pun boleh claim EOT and so on. The rest you can read lah. Termasuk juga any act of prevention or breach of contract by the employer. Kalau employer ada action yang melanggar kontrak pun boleh bagi EOT. Okay. This one is clear. The timeline. You refer back to 3.1. Application of EOT by contractor. This one is compulsory. Kalau tak ikut this timeline, contractor, architect boleh tolak EOT. So contractor must follow this procedure. Okay. Within 20 days to submit notice. Okay. Date from the instruction or relevant event. Another 20 days after end of the event, give another details. Okay. Submit details. So upon receive, architect might request for another 20 days to have further info. Okay. And then for the next 20 days, contractor to provide further info. This one all maximum lah. Okay. Maximum 20 days maximum. Kalau lebih, barat tak boleh lah. Kontraktor tak boleh. Let's say lebih 20 hari. Kontraktor barat tak boleh claim EOT. Yeah. This is the timeline given. Then the architect or reject award EOT within 6 weeks. Okay. Okay, class 24, our last class. Okay, I tak nak go details. I just explain. So I said you must read side by side. Dalam clause, what's the difference? The difference, 23 talk about money, the claim on the money, on the time. 24 claim on money, loss and expense. Okay, loss and expense. The structure almost the same. The procedure almost the same, 20 hari. Another difference is, dia beza dekat relevant events. Kalau dekat EOT, they call it relevant events, whereas clause 24, they call it caused by matters of affecting the regular progress of the work. Panjang, it's long. There's not relevant event, they call it matters affecting the regular progress of the work. Okay. The difference, okay, you can see here. Okay, 24.3 matters materially affecting the regular progress of the works. Contractor boleh claim duit, loss and expense if occurred due to here A, B, C, D, not received in time to CAI, blah 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 blah. Okay, if you read carefully, this clause, subclause, same with clause 23.8 dalam EOT, sama means that you boleh claim contohnya item A, delay B, delay by employer giving subposition. So kalau delay subposition, contractor boleh claim EOT dan dia boleh claim juga duit. Kalau ada lah. Contohnya dia dah lambat masuk site tapi dia dah order dah machine semua. That cost dia boleh claim lah. because dia dah melanggar rugi, kan, boleh claim. Tetapi tak semua. Other than this, ada yang dalam clause EOT yang tak boleh claim kat sini. Kalau you perasan, item tu ialah item-item yang melibatkan act of God ataupun beyond control. For example what? For example, force majeure. Force majeure tak ada. Force majeure tak boleh claim kat sini. Sebab dia melibatkan kos yang tinggi. Contohlah item tu, tapi you mungkin boleh claim, you might claim under clause insurance 20. But not all. You read back clause 20, you can find out that, okay, in clause 34, there's item that you cannot claim due to act of God, due to beyond control, force majeure, cuaca dan sebagainya, banyak. But you might can claim under clause 20, insurance. Then that's how you read. So all sub-clause dalam 24 boleh claim dalam EOT. Tapi not all dalam EOT boleh claim under 24. That's the idea. Okay, sama 24.4, any loss and expense money yang dah ascertain atau yang dah confirm akan dimasukkan dalam cert, interim cert yang boleh dibayar lah. Okay, that's all. That's all for today's session. Class 1 until 24. We already finished. I hope you already grab the whole idea of at least until class 34. I tengok ada soalan ke? Okay. I tengok soalan dulu. Mana yang last saja? What is the latest one? If an engineer use PAM contract to administer the project with no architect involvement, can he use an AI? Tak boleh lah. Tak boleh. Unless you change the contract lah. You change. Boleh lah. You faham tak? This is the idea. The idea, the idea is PAM contract is drafted for building works. Okay, for building works. Okay, I can accept there's a project yang memang engineers boleh jadi SO atau boleh jadi lead architect. Lead consultant. I accept that. But you must find, let's say lah you kata you tak nak architect ada sebagai architect. Because dalam PAM contract, there's a word architect. So what the best you can do? You change lah. That's the best you can do. Or you can use your contract. Kalau civil, you have engineer's contract kan? That's your option. But when you change, you can change everything. Architect tu dah tak ada. You ganti dengan engineer. But contract client must agree lah. It's a tough work lah. You want to change everything. I have heard about remeasurement. Does that mean contract sum can be changed based on the new quantity? Will this be shown in contract? What you mean remeasurement? Remeasurement ni normally kalau case provisional quantity, you akan remeasure. You nak remeasure item. Sebab in contract, the only thing we remeasurement ialah provisional quantity. Why? Because contoh piling work, you cannot define the exact quantity of the piling because due to tanah kan, the soil, the depth, you cannot determine. It can be 10 meter, it can be 12 meter, depend. So let's say the final length extra due to you pile extra length required. So that's what we call remeasurement. Itu je dalam kontrak. Yang lain tak ada. Of course lah. Then become under ni dalam clause 11 adalah 11F tadi ya. 11.6F tadi ya, provisional quantity. Can I say the engineer role is more to assist architect in project? Of course, yes. Dalam PAM contract, that's your role. Because as mentioned, architect, AI carries more weight. Betul? Alright. Even CPC issue, betul? Because our topic today is PAM contract. So, memang architect kat depan. Bukan engineer. Bukan engineer, bukan apa. Architect kat depan. Engineers will assist. Correct. That's the word. Correct. IR Suzalini. Okay. Oh, is it because we are discussing on PAM contract? That is why I get it. Yeah. we are discussing pen contract. It's a building works. Kalau dekat luar, kita panggil arkitektur SO kan? Panggil arkitektur SO. Can the DLP be extended? Boleh, yeah, can. You read back at the appendix, what the appendix said. Appendix said, it can be 12 months or otherwise stated. After CPC, consultant found that there are so must be done by contractor, which is ration from original. After CPC, consultant found, how come CPC issued? Consultant found that there are extra work must be done by contractor, which is variation from original contract. Can we issue AI after CPC? This variation, is it agreed during construction or after CPC? Dalam kontrak, kalau you kata that if you say that this variation is supposed to be done during construction, then too bad contractor kena buat juga. Kena buat because agreed during construction. Dia mungkin miss out ke tertinggal ke apa, dia kena buat. Kena buat. Tapi you talking about variation after CPC, yang only valid ialah related to authority saja. Related to authority saja. Kalau contractor nak buat, dia dah jadi another agreement. It can be a supplementary agreement, whatever, but nothing to do with original contract. Unless related to authority, yang clearly stated dalam clause 11 kan. Then only you can use AI after CPC. Itu yang clearly stated dalam contract. Okay, clause 11. Okay, how to define exceptionally inclement weather? Need to go to check with meteorological report. Okay, kalau you baca buku Oren, dia ada explain lah pasal ni. Buku Oren apa tajuk dia? Saya lupa lah. PEM ni lah. Dia, tapi in general, exceptionally inclement weather ni lah you can relate with cuaca-cuaca yang you tak jangka. Again, for example, you kata hujan lebat. Dekat Malaysia ni, you dah jangka dah hujan ni. You dah jangka dah. Of course, for example, dekat Johor dengan Kelantan akan different. For example kan, because Kelantan, Terengganu dia akan expose dengan monsoon. Walaupun Kelantan, Terengganu is the weather is very bad compared to Johor, for example. Right, very bad. But again, you dah anticipate awal, you tahu dah dekat Kelantan monsoon bulan 12 mesti teruk punya. The only thing lah you tak tahu how bad it is. So under this relevant event, exceptional weather is something yang you tak jangka langsung. Kalau dalam buku Oren tu dia explain, kalau in the case of hujan, if you can prove that the 5 years weather punya data from jangkaan cuaca, say that that area memang tak pernah jadi hujan banyak ni. Tiba hujan paling teruk, then okay. That's the thing. Data you must refer. That's what exceptionally inclement weather tu. Of course, you check with meteorological department lah to clarify, to confirm. We can include a supplement clause to substitute all to engineers. Again, your question, you want to change the contract, in practice up to you lah. You change lah. Tapi nama dia bukan lagi standard, dia dah bukan standard form lah. There's no more standard. You tukar lah perkataan apa pun dalam kontrak tu, dia dah no more, satu perkataan pun you buang, is no more standard form. Because what we are learning today is standard form of PEM contract. Standard lah. Yang PEM dah buat, dah gubal, dah draft. You change satu perkataan je, is no more standard. Ingatlah, apa-apa pun. So kalau you nak tukar architect to engineers, buatlah. Tapi you know lah the consequences. Mungkin ada effect dia lah. Mungkin ada kesan dia. How to interpret the allowable duration involved for latent defect based on date of correction, based on limitation on or max. How to interpret the allowable duration? Okay, now we talk about PEM contract. Okay, I dah explain tadi. Dalam PEM contract, 3 kali je. Tadi, CPC, critical defect dengan SOD after end of the LP. But if you want further argue or further you want to go deep lah related to defect, yes, you have Limitation Act to cover the buyer, because under contractor with employer, contractually habis DLP habis lah under contract, finish, cuci tangan. Habis dah. End of contract. Tapi let's say the issue still occur dan tak puas hati. Ingat, apa-apa kontrak ni dia ialah satu yang mengikat dalam certain period. Kan? SMP ke you buat kontrak ni ke period. Apa isu-isu berbangkit lain, you akan refer Limitation Act lah. Dan dia akan jadi court litigation. You akan refer court lah. Kalau betul ada isu berbangkit lah. Ingat tu, apa-apa kita ni, apa-apa pun, perundangan yang ada tu dah habis, dah tamat, you akan refer the ultimate, which is court lah. You can conclude. Any other question, you boleh fikir balik, boleh sambung lagi next week lah. Kita ada remaining clauses, right? Oh, lagi. Latent defect can by Kim Singh. Latent defect can claim from employer if the cost occurred after 10 years. If cannot, should claim from contractor or contractor. Ini tadi, dia tie back balik dengan Limitation Act. Limitation Act. Dia kan tie back Limitation Act. So decision court lah. Kalau court kata employer kena bayar, boleh bayar lah. Kalau tak lah. You nak insurance, tak insurance semua after that. Decision after that. Insurance, ingat, insurance only cover 3 months after DLP. Okay, that's all lah. So any next further question, you can ask next week lah. We have remaining clauses, 25 and 40. All right. So I should end this session. Aimee, you want to conclude?
Okay, all right. Thank you so much, Architect Fakri. For everyone, next week we have session number 14, PAM Contract 2018, Part 2. We will continue from clause 25 until clause 40. Also with Architect Fakri Rahman. So if you have question, you can still ask him next week. Tata minggu depan Fakri banyak gila soalan. Soalan-soalan terkumpul.
Aku rasa itulah sebab soalan banyak ni.
Soalan terkumpul. I would like to add on a question by Wayne just now, whether you can include a supplement clause or substitute architect to engineer, just like what Architect Fakri mentioned just now. If you change any word from the standard form of contract, PAM contract 2018, it will no longer become a standard. And I give an example. PAM contract 2018, it is tied to PAM. Okay, for example, like under clause 36, which is next week you will learn about adjudication, for example. So if any of the contracting party, they fail to reach an agreement to appoint an adjudicator, so they can apply, either party can apply to the president of PAM to appoint an adjudicator, for instance. Or you can, if you have been to PAM Center before in KL, we have a proceeding room for adjudication, arbitration with regards to PAM contract. So if you change anything inside PAM contract, you are no longer tied to PAM. If you have any issue, PAM will say we have nothing to do with you anymore. The contract that you're using is no longer PAM contract. That is a custom-made contract, whatever contract that you're doing now, no longer the standard form of PAM contract. Okay, so I would recommend if you still want PAM to assist you throughout the contract, meaning, for example, like the role of the president of PAM and so on, do not change anything. Unless, like Architect Fakri just now, if you're okay with the consequences, then go ahead lah, because this is a standard. If you change, it is no longer becoming a standard. Okay, so thank you so much, everyone. Don't forget to scan the QR code to sign out. So we will see you next week, also with Architect Fakri for PAM Contract 2018, Part 2, Clause 25 to Clause 40. Okay, thanks, Fakri. See you next week.
All right, welcome. See you.
Bye.